Relief may be granted to file appeal without certified copy.
When was the
Group
order?
8.
Huh?
Group 8.
When was the order passed?
On 24th.
Then when did you apply?
I applied for zero certified copy 24th November. Extremely urgent. Urgency is this.
Leave granted.
Lordship, another Lordship, leave for filing memorandum of appeal, Lordship, without certified copy, Lordship. 2nd December, Lordship, order passed. Lordship, matter pertaining to Jalpaiguri circuit, Lordship. Next, Lordship, matter is pertaining to Jalpaiguri circuit, but Lordship is being heard in the principal bench. This particular matter, Lordship.
Which this matter?
No, I'm a separate matter, my Lord.
We understand.
Lordship.
So what? The single judge passed the order.
My Lord, passed an order whereby, Lordship, my contention is that I have not been served with the copy of the petition. I am an added respondent, but I am not being heard, Lordship. And the matter may be heard out in today, Lordship.
Not heard out today.
Lordship,
when was the order passed?
2nd December, Lordship.
Then when did you apply for certified copy?
3rd December, Lordship.
So what is the urgency?
Lordship, urgency is, Lordship, this matter, the main matter, Lordship, today is going to be the last hearing of this matter. My Lordship, this appeal, Lordship, is an intercourt appeal, Lordship, challenging an order whereby the added respondent have been denied to be heard without giving any,
Sir, what is the urgency?
Lordship, today, Lordship, this matter is going to be finally heard by the single bench.
So you should have come earlier.
Lordship,
not just on the basis of that pass an order of stay.
Lordship, 2nd December, Lordship, the order has been passed.
You go to the court and say that I have not been heard. You heard me, finished your problem solved.
Lordship, I had made an application, Lordship, on the 1st July. But Lordship, on 2nd December.
So you must not have told the single judge properly that you heard me.
Lordship, kindly give liberty to.
No, this sort of, you don't allege these things that I was not heard.
Lordship, I'm the fact, Lordship, I'm saying that I need to file this.
Leave granted.
My Lord, will excuse me to mention this matter, my Lord. This bunch of. Yes.
Today is not the mentioning division.
Yes, I understand. My Lord, illustrated, my Lord, my junior. The bunch of contempt matters was to be taken up.
Yes, we know that because on 8th it was not sure whether my brother would be here.
Yes.
So 8th we have not put that matter in the list. We will put it. What happened? Any development in the matter?
Yes, I am one of the added contempt.
No, it is that Rajiv Brahmo matter, no?
Sushanto Ghosh, that a bunch of contempt application was filed. Added.
I am appearing the applicant in Sushanto Ghosh. I am mentioning the same matter.
Sushanto Ghosh.
Upper primary matter.
Yes,
upper primary matter.
Sushanto Ghosh.
So,
no development has taken place.
Yes.
I am appearing to the applicant Sushanto Ghosh. No development has taken place since the Lordship's last order.
No further development.
No further development has taken place.
Mr. Balaji, then wait for some time. Unnecessarily, we will put it in the list. They are in the process, we were told. The government is being conducted. We asked the Advocate General to appear also.
My Lord.
Yes, what happened?
What I have heard is that there was a meeting with the Principal Secretary and the Learned Advocate General. And he was to appear on the 8th. But since it was not in the list, it has not been. So it cannot be said that there were no developments.
Dr. Patru, please inquire and tell us.
Yes.
Unnecessarily putting the matter in the
No, that will not help.
So if you kindly inquire from the Advocate General as to whether there had been any constructive process generated.
No, there was a discussion after which we were told to submit further certain documents which we have submitted on Friday, I believe. And so we are still working on it. We are still working on it.
Mr. Balaji, you wait for some time. Let us see what is the development. Hopefully, if it is by this year it is done, then the remaining council will be conducted.
My Lord. my lord.
Yes, yes, call the, what you are mentioning, sir? Huh?
Senior was there.
Yes, call the list.
Item number 1.
That
certificate.
who is for the state?
But, Mr. Shishano Banerjee, I personally yesterday, I personally met him, I requested him to be present today. He said that yes, we have watched the list, but we have missed the list.
We have,
Watched the list, the matter in the list, but we have
where
missed.
is he? Where is he?
I personally requested him, what more I can do.
কি দেখি
If your lordship kindly takes up, দাঁড়া, তোদের কোনো বক্তব্য নেই, আরে ফোনটা কর বাবা, কতবার বলবো তোদেরকে, এখন তো পা ধরতে শুধু বাকি রয়েছে। Last occasion, your lordship certain documents.
to just
But,
see, ask Mr. Bandyopadhyay to hear.
shall we come at 12:30? Item number 4, before Justice Modhuresh Prasad, I have a matter.
All right, come at
This is
12:30.
12:30.
12টায় কিছু ফিক্স আছে? ঠিক আছে, থাকুক 12:30। Yes.
Item number 2.
To be mentioned, no? Civic Park.
সেখানে প্রসিডিং করেনি, ওরাও কোনো এফার্ট নেয়নি, সেই জন্য ইন্টারফিয়ার করি, ঠিক আছে? We have to deal with the argument that it was a fake certificate. সেটা তো কিভাবে কভার করবো এই জায়গাটা Have you given the notice?
Lord, I have given the notice.
Where is
but
your notice?
By mistake, it has.
Sir, what,
Yeah.
madam, why?
Lord, it has been served. Lord, I can give it, Lord, within half an hour. Lord, I can deposit it. Lord, I personally informed Loknath Chatterjee and Srangsu Bhattacharya who are appearing in the matter, including Smita Saha. Lord, the service has been done, Lord. Your Lordship, I can deposit it by mistake. Lord, I had carried it at home and it remained there. But your Lordship can take it from me, I have served. Lord, this was originally filed in Group 2. But later on, my Lord Justice Viswajit Basu released it and it was taken up in Group 9 because it is with regard to the cancellation of scheduled tribe certificate. My Lord Justice.
Did you deposit that 300 rupees? Have you checked up the file at all?
No, my Lord, I have not.
Pass over. Or you do the needful, it will appear tomorrow then. There is a payment of a deficit.
My Lord, that I will do within half an hour.
No, when will you do? You mentioned yesterday. We
My Lord,
believe
we mentioned it for the
you have,
purpose
your
of
juniors have not seen the file.
I am very sorry, my Lord, we will do it. It has been paid.
Theater that.
It has been paid, my Lord. I am told by my junior, my Lord.
Insured. has been paid. Where is the writ petition copy, that demarcation you made? You said na in writ petition wrongfully you gave rule 9.
Lord, in the computer form of the appeal,
Yes.
it has been made as a group 2 and the Calcutta University Act, my lord. But my lord, it is group 9 matter. My clerk has filled it up wrongly. This is what I am saying, my lord, in the computer form. It is group 9 matter.
Initially, it
Group
was
9
filed
matter?
in group 2.
Uh-huh.
Then initially it was filed in group 2. Then court Mala directed, let this matter be taken up by group 9 determination court. That is why this is group 9.
Group 9.
We have been informed by the learned advocates appearing for the respective parties.
Grateful Mala. Didi naam ta diya.
Yes. Item number 6.
T.
3.
4. That's special educator matter, my lord.
Yes, where is?
6, my lord, I have to respond.
Where is Dr. Patra?
He's standing outside, my lord. I had to talk.
File to the. Yes, Dr. Patsu, any development?
What had fallen from the court on the last day, that they will not press, they will withdraw, and we will do it. But that is the difficulty, is that your lordships have already passed an order directing us that not to entertain any further cases, those who have approached the court after. So,
We are not commenting on that. We will
no,
see.
but if I take any action in spite of the fact of your lordship's order that we are to entertain only those candidates who had approached during the lifetime of the, during the online application process was going on, during that period. So now if we entertain, it would be violation of the order, or it will also raise many other questions. It will raise many other questions. We had filed an appeal, your lordships had dismissed the appeal, but had observed that no other candidate.
That order is here.
Yes,
Oh,
yes.
and
They are in
it's-
Obik.
Obik.
Yes.
Yes.
It is made clear that this order shall not be treated as a precedent by any candidate who did not approach the authorities or file a writ petition to that effect prior to 24th September 2025. I think learned senior friend is referring to this.
Yes. Earlier order a copy.
Dr. Patro, we can clarify in this manner that in the facts and circumstances of the present case, the order passed by the coordinate bench is distinguishable. And we are permitting we can permit the commission to call for to accept an offline application from him, and in view thereof, the petitioner withdraws the present application.
Firstly, offline, if I accept, I have to convert it into the online. It has to be fed into the system. That would be a
No, what is the
huge
system?
exercise. Yes,
In that case,
fine. The system is online. Everything is automated. It happens
right, but in
automatically.
that order, we directed acceptance of an offline
Which
application.
we had to convert into feed it into the online process, or it will not
No.
work.
Now you tell us, we can safeguard you from that. Or if we go into recording your submissions and his submission, then it becomes a decision on merits, na?
Yes, that possibly will be necessary. Why? Because my learned friend is not satisfied with only appearing in the teacher eligibility test. He also wants to participate in the recruitment process.
No, we are not granting that prayer. That will be in terms, that was there, you pointed out in the earlier matter also. The participation in TET will not give an automatic right to pursue the
Yes.
recruitment process. But
Yes,
that you have told us. And I think we recorded that also. It is solely taking into account that the appellant's grievance is confined only to denial of his right to participate in TET. We have made it clear.
But then this will open the floodgates. Everybody who wants to now sit in TET they will now start approaching.
Or you're wrong, they cannot suffer, Mr. Dr. Patro. You also being an officer of this court have seen that what has been done. We understand your constraints. That is why we were saying that if it is permitted and he withdraws, then the problem gets solved.
I know. In a true sense, this is actually not a wrong. This is our interpretation or our intention, not our intention.
Intention has to be transmitted through your actions.
Yes.
Your intention is good, but your transmission is bad. Then not naturally everything spoils. Do it. You give an offline application. You file an offline application. We are keeping the matter pending. Yes, by today you file an offline application.
There are 8 candidates.
They can rush. Ushaba is there, Malda is there, Gajol, and
circuit bench হবে না?
না কেন আরে এখনো নোটিফিকেশনই হয়নি, সব মালদা পাঠিয়ে দিচ্ছে।
No, you have to put in, where was that online submission document?
No, there's no document.
Last date of receiving online was 24th September.
Yes.
Have you seen notification?
Goes against you. The thing which you are thinking that it will open a floodgate, it will open a floodgate.
Yes.
You must appreciate that and do the needful.
I was hoping the court would appreciate.
Achha, we keep it day after tomorrow as to be mentioned. In the meantime, you put in the offline application.
একটা প্রোফর্মা পাওয়া যাবে ফর্মের কারণ
No. Give an offline application. With the details, you give the offline application to the commission and give a copy to Dr. Patra.
In the previous matters, what was done is they came with the offline applications to our office and we made the candidate, we opened it, the online and we made them put it into the online application.
Then they will visit your office tomorrow morning.
That
জাস্ট ইনস্ট্রাকশন
You do it.
আসতে পারবে কিনা জিজ্ঞেস করতে
You along with your offline application, you meet with the secretary. You meet with the secretary tomorrow at you will go at 11 o'clock.
just my lord, I'll just inquire the Malda person will be able to come or not. Malda and Gosava.
He has to come if he wishes to appear. Commission will not wait for
Yes,
you.
yes. I would have one day. বাগুইয়াটি কোনো অসুবিধা নেই, গোসাবা একটা আছে, মালদা একটা আছে, আর কিছুই মেদিনীপুর চলে আসবে, আর 1.5 ঘন্টা লাগে। আর
আজকে হচ্ছে কি বার? আজকে মঙ্গলবার, বুধ, বৃহস্পতি, শুক্র। Mr. Lahiri,
Yes, I'll
make the things easy.
Yes.
You send your client with the offline application to the secretary.
Yes.
And if the secretary will put in as understood what Dr. Patra, they will open the online and enter. If that is done, you come and tell us on that day. We will say that the appeal is dismissed as infructuous.
আস্থা হবে।
And he keeps it. Otherwise, application will not be accepted.
Friday to be mentioned. Friday to be mentioned, but you have to go when? When will you go?
Tomorrow.
Don't go at different times. Don't send the candidates on different times.
no,
They
fix
will
the time and date and they should approve.
tell us now. Acha, we informally make it 11 o'clock tomorrow, secretary's office. But Mr. Lahiri, you ensure that all of them goes together.
Yes.
Otherwise, we may not be able to help you.
I'll start the process here.
And you, Dr. Patra, you give that necessary
I'll inform
instruction.
him.
From which district?
One from Malda, others from 24 Parganas. North will be arranged, Purbo Medinipur, and one
Acha,
from
we are keeping it at 2 p.m. You take
Yes.
and you at 11 o'clock tomorrow they will go. You intimate them and come back and tell us. Then we will adjourn it.
আজকে দুটো 2 p.m.
At 2 p.m. if I'm engaged, my opinion.
No, you have to be there. Tell us when will you be there? 1 o'clock or 2 p.m.
No, let it be 2 p.m.
You ensure in the meantime, you inform them, all of them together has to go and meet with the secretary tomorrow at 11 a.m. with all documents, Xerox copies, documents should be attested and everything. Don't create any formality to be conducted. And come and tell us on Monday whether it will be tomorrow, then we will keep it day after tomorrow. Tomorrow or day after. Yes, all the
instruction দিয়ে দেবেন আর secretary accept করবে।
yes. Dr. Patra ওই দুটোর সময় বলে দাও।
You also give necessary.
Yes, I will discuss whether there is any other.
আবার কি ডিসকাস করতে?
You give this information just that they will
The
come
information,
and
the
accept
moment
it.
I give the information, I will get your feedback.
And accept it.
Talk with the secretary so that it can be done. Yes, next.
And I appear for the commission on the.
Lord, I am appearing for the commission, my lord.
Yes.
Is that matter yesterday, your lordship, heard the matter, my lord, in respect of second SLST selection process, my lord, I could not be able to fill up the form in respect of my prior teaching experience in respect of 19 selection.
Mr. Bandyopadhyay, anything can be done.
My lord, not possible, my lord. I respect your lordship's view, my lord. I respect. But what has happened, my lord, there are in queue, there are 100 litigations are there, and so many persons are also there, my lord, those who have missed it. Either 19, 11, 12, my lord, options was given. They were not so careful up to August end. 12th August, up to 12th August, the option was given. They didn't care. 11, 12, my lord, he has given it, not in 19.
Well, at 11-12, I have been out from the selection process.
Kindly see the.
You can't take a chance, na. There is no scope for taking chance.
He has himself in his representation.
Yes, yes. Well, I am not.
That has been similar. That has been in the impugn order itself, my lord.
But I shall be out of from the, my lord, competition. If 10 marks is not added, subject to, my lord, subject to
You are
correction.
responsible for the.
Yes, yes, my lord. My entire
Huh?
life will be spoiled.
You cannot put blame on.
No, no, no. I am not.
on any
Subject to
person.
repeat.
You yourself did not.
Yes, yes, my lord. It is true, my lord.
My lord, it has started to come to appeal court now. Your lordships will find it has now started to appeal court. The beginning fast court has, in both sides will come, and my lord, now we are in a very difficult position, my lord. Very difficult position. We have to complete it by 31st December.
My lord, in this scenario, my lord, my lord, only submission, my lord, I shall.
Mr. Bandyopadhyay, can we, subject to your record, can we say that this will be not treated as a precedent in other matters?
No, my lord, that would not be. My lord, kindly appreciate that that's a violation of Article 14 also. Kindly appreciate. There are so many persons are there. But had there been any chance, I would have. But I respect your lordship's view, my lord. I understand you.
Wanted your assistance, whether it can be done.
My lord, not.
Not saying you concede. We are not saying that you have.
My lord, no, there is no scope to do it. Otherwise, I would have done it.
Okay.
Record any order, my lord, don't record any sub, just like previous matter. I shall approach to the commission. If commission can do something, don't
What
record.
will the commission do?
My lord, it is, my lord,
Mr. Bandyopadhyay says it will not be done. Unnecessarily keeping.
No. I mean, Mr. Bandyopadhyay, subject to corrections, he is apprehending several other candidates might come.
Naturally,
My lord, that is, be that as it may, my lord, I am suggesting, my lord, to Mr. Bandyopadhyay and before your lordship, my lord, I shall approach. Don't pass any order. I shall approach to the commission if possible, my lord. I shall be out of, my lord, if possible, my lord. Don't pass any order. My lord, treat me as a special case. I will be thrown from the competition, my lord. On the other hand, my lord, I am a job loser. If, my lord, if possible, my lord, I approach to the commission. Commission do needful, my lord, don't pass any order. Keep it on Friday.
I will request my learned friend. Please,
Just
that I will request my learned friend to go to Supreme Court and get an order to this. We will be helpful. I am just requesting you. All we are bound by the Supreme Court's order.
Supreme Court.
Go to Supreme Court and say, I do not mind.
Result has been published, but verification list has not yet published.
Result has been published.
Written exam result published, but verification.
Mr. Ghosh,
my lord, I will be thrown.
We tried our best. We requested the councils. But what can you do? You have to stop sometimes. You have to stop sometime.
My lord, you have, my lord, kindly, I will be, my lord, but I am telling your lordship, what is the difficulties arise when the 11th, my lord, applicant made, my lord, applicant made, my lord, 10 marks in respect of 11-12. When the 11-12 marks result has been published, applicant has not come into the zone of consideration. Applicant has an hope that I will be come in the 11-12 selection.
No, we don't understand that why she will indicate that in 11-12, but not in.
Yes, that is the technical glitches, my lord.
So they are technical.
It is my fault. My lord, it is my fault.
Mr. Ghosh, say something believable. It is not that only 10% were there. Thousands and thousands of candidates are doing like this.
But
today if we direct you, this will automatically, because your submission is itself showing that how the precedent which we said in the earlier matter, you are taking example of that. So there will be flooded with litigation.
Yes, that is why, my lord, don't pass any
order. So we are not passing the order. We will take it up after vacation. You take necessary instruction. In course of hearing, Mr. Ghosh Chaudhary, learned advocate appearing for the appellant, prays for an accommodation to avail necessary instruction. In view thereof, list the matter for further consideration under the same heading in the daily supplementary list of this court 1 week after the vacation.
Not deep level list. No, I'm sorry, my lord. Kindly excuse me, my lord.
No, why you will be sorry? You're appearing on behalf of your. How can you concede? You cannot concede.
Nandiju. Grateful.
Yes, next.
Issue number 6.
Rebuke everything. Response number 1. Not earlier there was a
direction of exchanging affidavits upon Malat Section 5 application. Malat, they have already filed their opposition, but I could not prepare the reply. Malat, kindly grant me 1 week time to file the
So we dismiss. What is the problem? You're not filed on
3644 days. 4359 days.
What is the main matter about?
higher scale of pay.
Oh, that physical education.
No,
Physical education.
conversion. Non-relevant subject.
No.
Malat, order was
For
passed.
the writ petitioner.
Which position?
Yeah, Malat.
Oh, state has come up in it.
Malat.
How many days delay?
4359 days.
Eh?
4359. No, 3644 days. 4359.
My brother's judgment is there.
Malat.
And
My brother is against you.
and
I
Mr.
mean to
Bari,
say-
there are some other name of the respondent number 5 of the memo of that or file. Recently Supreme Court. Supreme Court.
I'll remove the defect.
Recent judgment. 12 September 2025.
Yes,
That is against the state.
We know.
Justice Padriwalan.
Acha, you are showing us that judgment. Acha, we will give you another judgment. Please go through that. You are not listening to us. We are giving a judgment.
Malat, I'm taking the reference. Malat.
No, not reference. It is Shioraj Singh. Shioraj Singh.
Yes, Shivraj Singh.
It was an order of 9th October 2023. You'll get it in the server. Supreme Court order.
Supreme Court. Shivraj Singh.
Acha, Mr. Ghosh, learned advocate appearing for the writ petitioner.
Yes.
Item number 7, Malat.
Yes, to change his stand from here, state to petitioner.
I am for the writ petitioner respondent, Malat.
And also
Yeah.
higher scale.
It's also higher scale.
And also higher scale.
There is a direction of exchange of affidavits in the stay application, Malat. I have prepared, but I could not affirm it. Only 2 days time, Malat, to affirm the affidavit. I have already prepared.
Next Thursday.
My lord, in this matter, only my lord my lord's pleasure was that my lord school service commission be my lord appear before your lordship.
Oh, Dr.
Yes,
Patro,
yes,
this
that
is a
my lord,
matter.
first
That was
RLST.
that first LST.
First RLST,
Yes, madam.
his submission, there was no
We
different.
remember. Dr. Patro, this is a higher scale matter
Yes.
pertaining to physical education. Boishali Bhattacharya and others are there, which says there is no honors category in physical education.
No, this is not, for us, not physical education.
It's history.
It's not physical education, it's history. Man.
Social science.
I relied upon a circular of 1999, circular 155 AC.
Yes.
Where it is written, if whatever qualification written in the recommendation letter by the School Service Commission, he will get salary for the assortment. That's I have relied upon
Then
that.
why did we ask?
She opted for postgraduate history, postgraduate. But having her
Postgraduate qualification.
Postgraduate. He did not opted. It was submission of Mr. Bari that there was no different selection. One selection was that. That
Yes,
is why my lord.
honors and pass.
Honors and pass was not there in your subject. In
No,
your
in the first essay, SSC examination, there was no different procedure.
what is the history?
Yes, my lord.
Dr. Pachu, can you tell us in the first SLST whether there were two separate examinations for pass and honors in respect of history?
Possibly there was, but I will confirm it. I will confirm it since it is being kept on Thursday. By then I will come back with this.
Yes, because if there was no such option, then we can hear him. But we already told him that so far as our information goes, there were two separate tests.
Yes.
Having consciously opted for pass category in spite of having post graduation,
Yes.
he cannot turn back and say that now give me the post graduation.
No.
Because the subsequent amendment of the School Service Commission control of expenditure, that section 14 another subsection was added.
What you have mentioned, that will be taken into consideration. You might have higher degree, but
and you will have the permission to apply and participate again for master for honors category.
Yes.
Then you get this. There is no.
In this that I have also annexed the School Service Commission Act 1998, where is the two different procedure. One is for secondary school assistant teacher having past graduate, and for higher secondary, yes.
Yeah, understand.
I have annexed that rule also. There is nothing, man.
Dismiss
Well, dismiss it after 2-3 days, man. Let it be, man.
We are not fond of dismissing. That is not the issue. The issue is that things which cannot be done, what can be done?
Malad, let it be ascertained from my Dr. Patro. Malad, let it be ascertained, Malad.
When did we keep it? Body structure third. The entry order is already there.
Entry order is already there.
Let the affidavit in opposition. Commission is a party here.
Yes. Oh.
Dr. Patsul and
Item number 8, Lordship, Mr. Bishwas appearing for the board, Lordship. I am giving short pass over, Lordship. Give me Short pass.
This is by reply.
Please appear.
Mr. Ratul Vishwas.
Ratul Vishwas for primary report. But he is answering this one.
Pass over. Pass over. Pass over. Ask him to come. Yes, next.
Number 9.
Down for the petition. My lord, matter, my lord, your lordship has heard it previously. My lord, this petitioner participated in the second SLST for 9-10. My lord, petitioner completed his graduation, my lord, from Raiganj University. It's a very unique problem, my lord.
In which subject?
My lord, with philosophy honors, with history as past subject. Now it is called as elective subject. Now, my lord, your lordship knows in our days, my lord, in past subject was consisted of 300 marks. And there was no semester system, my lord. Now, my lord, according to the new education system in Raiganj University from 2018, my lord, it has become semester system, and the pass marks, pass subject total marks instead of 300 has become 240.
Have become
240 total marks. Now, what is the problem here, my lord? For classes 9-10, there is no subject of philosophy. So I applied in subject history. History was one of my past subject, elective subject. But the total marks was of 240. But the, my lord, rule says, this commission, school service commission rule says that if you want to apply in any subject, the total marks must be 300. My case is, my lord, nowadays 300 marks in Raiganj University or Calcutta University, my lord, I've taken that instruction. My lord, nowadays 300 marks elective subject is no more in existence. At least from Raiganj University is the government of West Bengal recognized university. The total marks is 240 that I can show from my pleading. So what I am playing here, my lord, the word is in the rules is 300 marks. What I play, my lord, it should be 240 or 300 as the case may be.
Have you challenged the advertisement?
My lord, I have advertisement. I have prayed for modification of that portion of the in my writ prayer in the writ petition. I have prayed for modification of that portion of the rule schedule.
What did the learned single judge?
My lord, first learned single judge hold that I have not challenged the rule. Second hold that learned single judge, at my lord, with deepest of respect, have hold that I had the option of choosing 400 marks as past subject. And that is absolutely, my lord, with deepest of respect.
400 marks.
My lord, that is an incorrect submission. I can demonstrate from my result.
240.
It has to be 240, my lord. It is divided into 6 semesters. For first 4 semester, it is 240, and next 2 semester, it is 60, 60, 120. That is one first 4 semester generic elective. I can choose any elective subject, and 5th and 6th semester, my lord, subject specific elective.
Discipline specific.
Discipline
How
specific.
can we help you, Mr. Das?
My lord?
How can we help you?
My lord, if it is found, my lord.
Your application already date over?
No, my lord. I have applied. I have passed the written examination 9-10. In verification stages will be declared soon. My lord, I have been called. I do not know whether I am being called for verification. If I come within the zone of consideration, if I am called for verification, that list they have not published. Then at the verification stage, my candidature will be rejected that I do not have 300 marks in the subject I have applied for.
You come to us with that. Why you are wanting a decision of the court prior to that situation arises?
My lord, because since I filed this writ petition long before. Since
you are wanting us to do something which the commission is yet to decide.
But
maybe they are against you.
Yes.
So you have earned to be successful. Now you will, if you are not called for verification.
My lord, there is nothing in this.
There is nothing. No verification gone, then you come and tell us. Otherwise, we have to go into the merits and consider the matter.
My lord, may I most
or
humbly...
we can ask Mr.
No, my lord, may I pray for my lord may I submit one suggestion? My lord, your lordship will not hear this matter today. If I am called for verification, I will go for verification. Let it not be rejected and produced it before your court so that your lordship can decide it.
If they reject also, we will decide.
Yes,
What
my
is your
lord.
problem?
Yes, my lord. If they rejected, your lordship can.
When is the tentative date?
Nothing has been, my lord, commissioned for no notification has yet been.
Very good. Then in the meantime, let him use an opposition. You file the reply, come back to us.
Oh, no, everything
It has been filed. Oh,
Yes, opposition has been filed.
Yes,
Reply has
reply
also been
also
given. Let the verification list be published first.
on the prayer of Mr. Dasgupta, learned advocate appearing.
I am for the appeal.
I am appearing on behalf of the respondents if it is not.
That matter, my lord. Whether my client.
The last occasion lost was.
Just a moment. There are two appeals.
Yes, ma'am.
Two appeals.
Okay.
Oh. Party code হচ্ছে। Yes, tell us what are the facts?
My lord,
why two appeals?
Why two appeals, my lord? One appeal filed by my learned friend who is got second position in the package.
No, both are filed by you.
No, but two writ applications. One is filed by my learned friend
I
who
see.
got second position in the panel. And I am the first position in the panel. My service was approved by the DI up in the year 2009. 2014, a suspension order was passed against my client. I challenge the another petition, that is WPA 217
1217 of 2014.
That is pending. Thereafter, my lord, board.
No, and his writ petition was dismissed.
No,
what did he pray in his writ petition? Not to give you appointment.
No.
To cancel the certificate of the petitioners,
No,
appellant, because that certificate is apparently fake, and producing that fake certificate,
got the employment. Very good.
Employment.
Now, your writ petition was dismissed.
Initially dismissed, then restored, then finally disposed of.
Disposed of with what direction?
What direction? To the board to conduct the disciplinary proceeding and complete the proceeding. And if found that the appellant's certificate is fake, then the proceeding to be initiated and terminate. And my lord, I am the second impanel candidate. Within 6 months, the DI will directed to issue the appointment letter in favor of.
Your writ petition challenging suspension is still pending.
Still pending. My lord, thereafter, my lord, board hearing this matter, my lord. 2015. My lord, your lordship, you can see the order passed by the board. After next page, after careful considerations of the facts and circumstances, and after taking into account the relevant papers and documents and the submissions made by the concerned parties at the time of hearing, I, arbitrator, West Bengal Board of Secondary Education, in exercise of power conferred upon me under section such and such, secondary as amended order that as the matter is sub judice, the order of the honorable court be awaited. This is the order passed by the board in the year 2015.
Pursuant to which order? Which order?
Pursuant to the suspension order passed by the
Naturally,
board.
suspension was challenged by you.
Yes.
So the board did not express any opinion.
That is pending. And when thereafter, my lord, both the two writ applications clubbed together and hearing was done. My lord, at the time of hearing, my lord, I am not present in that hearing process. My lord, this order was part ex parte.
No, that
The order was passed by the learned judge. That is on that day, my lord, I am not present.
Well, despite service, now the appellant did not appear. Despite service, not a single time, my lord, 3 times. I serve a notice, he received. Despite receiving, he did not.
Have you initiated any disciplinary proceeding?
My lord, we have asked DI to hold a preliminary inquiry. We have received the inquiry report and show cause issued to lordship. This is the show cause. And
Cause to whom?
To his client.
Oh, he gave reply.
No, we have not received the reply.
Then you send it for preliminary inquiry.
We have already sent for preliminary inquiry, received the report of the DI. Prima facie shows that it is a fake from the report of the DI. Well, I have only one.
That point is not decided by the learned judge. My writ petition was not heard by the learned single judge. My writ petition should be heard.
Affidavit of service global.
ও যদি ওর সার্টিফিকেটটা ডিফেন্ড করতে পারে ওর কিছুই হবে না এখানে চেঁচিয়ে কোনো লাভ।
Now, what is the procedure in during preliminary inquiry? The person is heard.
No, it is not the procedure. Only after receiving the show cause, he will give a reply to it. If we are not satisfied with the reply, board will issue a charge sheet. He will reply to the charge sheet, and thereafter.
No, you issued the show cause.
We have not received the reply yet.
Then before that, you send it to DI.
No, that is the rule. Rule 5 says when we receive a complaint, here the court has directed us to hold a proceeding. So as per Rule 5, we have first asked the DI to hold a preliminary inquiry as per Rule 5.
Focus, when did you issue?
After receiving the report of the DI. Because
oh, I see.
We asked the DI to hold preliminary inquiry on 13th October 2025.
Yes.
We received the
after passing this judgment. After passing this judgment.
Order, there is a provision of statutory appeal.
Yes, Lordship. Now, proceeding just initiated. Well, let's start sheet. Thereafter, inquiry officer will be appointed. He will be called for hearing before the inquiry officer. Thereafter, inquiry officer will place its report before the board. Thereafter, final order will be passed by the board. And thereafter, challenging that, if he is agreed, we will go to the appeal.
It's a clause 4.
Passed by the learned single.
Yes, issue related, subject to the result of the disciplinary proceedings and the appeal.
My lord, your lordship kindly see, my lord, I have filed a writ petition challenging the suspension order. My lord, my applications was not heard by the single judge. My lord, I have not
When did you
represented.
file that writ petition?
My lord, in the year 2014.
Challenging the order of suspension. Suspension order was dated.
My lord, suspension order was dated.
July 2014.
10th July 2014. So in that writ petition, any order was passed?
No.
It was kept pending.
Kept pending.
Very good.
But both the
When the writ petition was pending, observing that the board said we are not going to decide the issue of
matter after passing.
this
We are
is
awaiting for the
proposal
order.
for approval of very good. Then
this order was passed. Well, subsequently, my lord, in the year 2014, this order was passed.
No,
My lord,
2014.
2024.
After 10 years.
After 10 years.
Which order was passed?
My lord, passed by the learned single judge,
but
which was in the challenge in this appeal.
Now, when did you file the writ petition?
2009.
I have challenged
after appointment of approval by service. Thereafter, he challenged this.
No, subject to correction. We have filed. I have filed a writ.
We'll hear your arguments later. We are trying to.
Yes.
2014 was the challenge against suspension.
My lord.
He was approved as the staff.
My lord.
Now thereafter, when was he approval given?
2009.
Approval was given in 2009. So on that year itself,
I have
filed a writ petition.
Prior to approval.
What was your prayer?
My lord, kindly my prayer for my lord, the cancel the writ petition of the appointment of the petitioner, and my lord complete the inquiry whether the appellant's my lord certificate is apparently fake.
So
and the entire selection.
That writ petition was filed in 2009 prior to his approval of his appointment. But thereafter, his approval of appointment was granted.
My lord.
That was also granted in 2009.
2009.
Now, in 2009 writ petition, earlier any order was passed?
No.
No.
In
your writ petition, he is a party?
Yes.
So, any affidavit direction was there?
Yes.
There was
a affidavit direction. Despite that, my lord, my learned friend client did not, my lord, file it. Though, my lord, the state has filed an affidavit and, my lord, the stating all the facts.
You gave 3 notices to him to appear.
Yes.
My lord,
yes. That is recorded in the order.
My lord, affidavit of service in earlier order, my lord, that was, my lord, taken into consideration.
This analogous hearing order.
Yes.
Passed when?
Analogous hearing, my lord, both the writ petition, my lord, togetherly to be heard by in terms of order passed by Honorable Justice Rajiv Sharma as his lordship then was 2000.
Where is that order?
My lord, 2017.
That you have annexed here. So in 2017, direction was given for analogous hearing.
Yes.
Can you show us that order?
Yeah, yes. Lord, Lord, kindly see.
Now, ultimately, it was taken up in 2025.
Yes, my lord. In the meantime, my lord, both the writ petition was, my lord,
matter was. We are coming back to you, Mr. Ben.
Take copy. I'm sorry, my lord. There is a one copy, my lord.
5090 he wrote writ petition.
This is my writ petition and my lord, my senior learned friend writ petition file my lord 2-1. My lord, there is another copy. Yes, it.
Writ petitions are dismissed. This was dismissal order by Rajsekhar Mantha.
Then my lord, it was restored.
Both the writ petitions were dismissed.
No, only one.
Subject to correction, my lord. One order, my lord, 2 writ petition dismissed. My learned friend
are wanting to see the order by which analogous hearing was
my lord, can I have give first order?
First order list the matter next week.
Leave the matter along with.
Yeah.
আচ্ছা 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 তারপর সেটা হলো which writ petition was due?
Writ petitions are dismissed. Yes.
Both the writ petitions were dismissed. Then that was recalled.
Then well recalled.
In 2022, thereafter the matter was finally heard.
My lord.
Now their affidavit direction was given.
Well, 2024. So there is no direction for affidavit. Well, the affidavit of direction passed by this honorable court, and my lord, we have served a notice, and my lord, the order.
Yes, Mr. Bench.
My lord, Honorable Justice Rajiv Sharma directed that both the matter heard analogous. Thereafter, matter was dismissed for default. Matter was restoration application filed only in connection with 5090, not 217.
Mr. Banerjee, your prayer was challenge against the suspension.
Yes.
You cannot avoid the disciplinary
No,
proceeding.
I am not avoiding. My lord,
Then why should we?
I am submitting before your lordship that your lordship kindly give direction that my matters to be heard by the single judge. First decided finally. My lord, I have not argued any point before the learned single judge.
Yes, accept.
Yes.
If even that is accepted, your suspension order was there. It has to culminate into a final order. The stalemate condition cannot continue for decades. Today, there is an allegation against
2009, he filed this application.
Mr. Banerjee, there is an allegation against you that you have a fake certificate. This allegation has to be either thrown away.
That point has not yet been decided. As because my lord 2009.
So who will decide it?
I have received. My lord, your lordship kindly.
Who will decide? It is the board. Mr. Banerjee, kindly consider that unless and until the board in that disciplinary proceedings hold no, your certificate is genuine or your certificate is fake, the issue will not be settled.
No, my.
So now ultimately the board has issued a show cause notice, has initiated a disciplinary proceeding. You participate that disciplinary proceeding. If you can successfully prove that my certificate is genuine, you will continue with your appointment and with your job.
No, my lord, your lordship kindly see the order passed by the learned single judge.
In an eventuality.
here and now. I am, my lord, just my prayer. The disciplinary proceeding was initiated 2014. That was not, my lord, completed. Let the authority be conclude the disciplinary proceeding, and what is the what will be the fate of the disciplinary proceeding? Then, my lord, appointment will come. I am not asking for here or give appointment.
So, Mr. Panda, what is the order? Order is complete the proceeding.
Yes, my lord.
If it goes against him,
then, my lord,
then your
yes.
right, you DI will take you appeal.
Yes.
So suppose it gets terminated.
Yes, my lord.
If it is an order of termination, there is a right under the statute to file an appeal.
Yes, my lord. Yes,
Appeal.
my lord.
Now that appeal, if it is filed,
My lord.
by the time you get an order in the appeal,
my lord,
this direction will operate.
Yes.
You will come into the picture.
Subject to correction. My lord, the disciplinary proceeding includes, my humble submission, includes, my lord, the appeal. If the appeal is, my lord, filed by the, my lord, appellant, and till the finalization of appeal, my lord, this order will operate. This order also operate. Well, I cannot file an appeal.
If
my lord,
this right
contest.
is modified subject to the result of the disciplinary proceedings or appeal, statutory appeal, if any.
My lord, the disciplinary proceeding, my understanding, it includes, my lord, appeal.
That is your contention.
No, subject to correction because of, my lord, the appeal in the part of the disciplinary proceeding. I am not asking for any appointment. Yes, I have no problem because one of if the authority, subject to correction, because subject to correction, if the the appellant is aggrieved, my lord, to prefer an appeal before the authority.
No, he may argue. He is arguing.
My lord, that is, my lord, in
advance we are thinking.
Yes, my lord. That cannot be, my lord, that cannot be considered before your lordship. That is even argument. If the petitioner is prefer an appeal.
No, why it can, suppose his service is terminated.
Yes,
let us see.
Yes,
if it is terminated, immediately DI will appoint you. His appointment will
subject to correction, my lord, this portion will be, my lord, amend, my lord, I pray for, my lord, the modification, because, my lord, the now after 2018 amendment, my lord, the board is the appointing authority. Here, my lord,
Here also, lordship. I cannot appoint, and board also cannot appoint because
then the order becomes unimplementable.
Lordship, because
order becomes unimplementable.
No, that, my lord, I shall pray for, my lord, the
modification
or correction before the honorable single bench, as and when he.
Very good.
No, that is in only for that portion. Only for that portion.
What is the appointment?
No.
DI কি করে appoint করবে? Shall issue appropriate order for appointment. So he will seek a modification on that.
Only this portion.
No. Well, here is also difficulty, lordship. Board.
Near power.
Well, here is also
Then do one thing. You will file an application for modification of that condition in view of the.
I also will pay for correction.
Correction,
Yes.
whatever it is.
Yes.
So give a copy to him before the single judge. He will.
Yes,
go
I will also
make his submission.
Yes,
subject to correction.
He will make his submission only to the effect which you are submitting, that it should be read, disciplinary proceeding will be read as inclusive of statutory appeal. Your version.
My lord.
He will make that. You are not required to make that, because when you will file for modification, he will, because what is
I may not
what
be
is
fileable.
his prejudice, he is saying that today, if suppose you terminate, he is a bad man.
Yes.
If you terminate me today and tomorrow if the DI gives appointment, my right to prefer a statutory appeal or to come to a writ petition will stand frustrated.
Subject to, my lord, my appointment, if he will have.
Exactly.
Subject to appeal.
So that modification he will pray before the single judge.
That is DI will direct, my lord, lordship, that is DI will, my lord, impose.
Where is that order?
My lord, may not be, my lord, subject to correction. What is the prayer? What is the prayer of my writ petition, and what
Tell us, are you filing any rectification application?
My lord, I can pray for before this honorable court. I can pray for
the result of disciplinary authority and statutory appeal, if any.
appointment.
সালিস
ও জীবনে আর
এইটা মডিফিকেশন করেছে
মডিফিকেশন সামনে ডিসিপ্লিনারি প্রসিডিং আর স্ট্যাটিউটরি অ্যাপিল গুলো তো রিট পিটিশনে আসতে পারে।
Well, statutory appeal cannot be considered as a part of disciplinary proceeding, Your Lordship. Disciplinary proceeding ends with board. Statutory authority is the Commissioner of School Education. Disciplinary proceeding concludes with the final order of the disciplinary authority.
Only joint priority body একজন করবে।
My Lord, new act. Where, my Lord, I just can't follow.
That the new act will be applicable here.
Regarding proceeding?
Regarding the new act where commission has been now new
Yes,
appointing
yes,
authority.
because disciplinary proceeding will be done under the new act.
A matter relating to a appointment held way back in 2009.
But Your Lordship, the new act will come into effect because Your Lordship, the previous act has been omitted, not repealed, omitted.
Oh, so I am to go to General Causes Act.
No, my Lord, that is also
What is the effect
that
of
will also be not applicable.
Then do one thing. Your disciplinary proceeding is continuing.
Yes.
You place the final order before us.
Lordship.
Yeah, he will participate. He will also participate. If termination is given, you come and replace the order of termination for us. And then we will, if it is terminated, then we will listen to his prayer that now give me appointment. Modify the order and
Yes, yes. And who will give appointment? That is also very important issue.
That is, my lord is saying that.
Yes. Board cannot issue. Board can only issue upon.
Court directs upon
Yes,
court.
only court's direction. No,
Court will direct, give appointment.
No,
In
that
terms of the order.
that case also who will appoint to Lordship? It is the managing committee who will appoint.
Clarify in your order. You will clarify in our order.
Lordship.
So when will you complete the disciplinary proceeding? Tell us.
Well, minimum 3 months. No, but in the statute রয়েছে।
That
No, your lordship,
order will
your
be
lordship,
subject to
your lordship.
No, you are not also a good person.
my
2009
lord,
fake
well,
certificate. You are avoiding the court.
No,
You
because-
took a writ petition and you
my lord,
slept. You are satisfied
2009,
with
2009, my lord, certificate has been given. My lord,
Sir,
2010, the same headmaster, he has given another certificate to my learned friend's client. Well, your lordship, kindly see 2009, page 36.
Lord, kindly see
The certificate which has been given by the
Kindly
headmaster.
see the thing.
Okay, it is the court will consider the same. We should not make any comment whether your certificate is genuine or fake. It is the fact-finding authority.
My lord, 2009,
yes.
my lord, 2009, headmaster giving certificate to me.
Maybe-
2009.
Maybe you
My lord,
read
he obtained certificate 2010. My lord, then the headmaster, the same headmaster given certificate that
Mr. Banerjee, your suspension order, board has not taken any decision. And you are enjoying your suspension, sitting at home getting the money. Let him go and file out fake certificate. Your conduct is not proper. This conduct is not proper, Mr. Banerjee. You obtained an order, suspension. Board said, I will not do anything. The writ petition is pending. And you are happy. Let the writ petition continue.
And despite notice,
you just challenge the suspension order.
Yes,
You
What
just
is
challenge the suspension order. Thereafter, you have done nothing. and you are enjoying the subsistence allowance for last 10 years. And despite receiving notice for 3 notice.
Yes,
he's
sir.
saying,
No, my lord, at that
and
point
we
of
believe,
time,
we believe the officer of
my
the
lord, at that point
so
of time,
despite receiving
No,
3
no,
notice,
your lordship,
you didn't attend the hearing.
your lordship,
Rather, you are enjoying the subsistence allowance, going on subsistence allowance. Yes, for 10 years you have enjoyed.
my lord, 3 notice, my lord, thereafter,
Not like the apparently, my lord, they kindly see
And
the
neither
evidence.
the school authority nor the board, no authority has taken any step to decide the matter finally. Whether your certificate is fake or genuine.
Genuine.
Only this fact. And one report from the concerned educational institution where from you passed, you got the certificate, will set the issue at rest.
And 2014, my lord, the district, my lord, the inspector of school, my lord, the East Singhbhum has, my lord, sent a report.
In such an eventually an order to the effect shall be passed within 3 weeks. Copy of the outcome of the decision by the district.
মন ঠিক করে নিতে হবে।
Say that the steps taken by the DI in the eventuality of termination, it will abide by the result of the statutory appeal if you prefer against the order of disciplinary. We will modify the order to that effect.
If, my lord, he has, my lord, preferred an appeal.
No,
if any.
DI has been asked to appoint you within 3 weeks. There is a confusion in your mind whether board will issue the appointment or not. That you will decide. What we are thinking is, what my brother is saying is that, right, because the proceeding, these things are of the year 2009, prior to coming into effect of the act. Now, as the proceeding is under the new act, appointment letter also must be issued by the board. That is the general convention. Now, we will say that direction upon the DI is within 3 weeks, he will take steps towards grant of appointment. And we will say, if he takes steps, that will be subject to the result of the statutory appeal, which he may prefer against the order of suspension.
Here, my lord, statutory appeal right always, my lord, there to the appellant.
We are only mentioning that. You are also saying that that direction will be subject to. If you are appointed, your appointment will be subject to the statutory appeal.
Well, that line has to be, my lord. That has to be incorporated. If it is.
If the appointment is given, that appeal, the appointment is subject to the result of the statutory appeal. That may be filed by the by the petitioner in WPR.
The present appeal has been preferred, challenging an order date
Yes.
Item number 8, Lord, you know, we have passed a seat over, Lord. Here, Lord.
Okay, Mr. Vikas has not come
Only
as yet.
Not today, not today.
Not today.
Yes, next, Dako.
I think here.
12টা ডাকো ডাকো
ও এখন হবে না 12টা হবে না ওটা সময় লাগবে
Mr. Sen, you are likely to advance any lengthy argument.
My lord, not lengthy.
He asked Mr. Mitra to ascertain whether you will at all proceed with the appeal or not. So when you appear, Mr. Sen, as was told by Mr. Mitra on previous occasions,
Yes, I have.
that the point he was urging, that Mr. Banerjee says the point which has been urged by Mr. Mitra has already been decided by the appropriate forum. So this appeal should not be, will also be guided by that order. This was his contention. So I said that you take, what is your contention?
My contention is that I said, please give short list of dates before your lordship. My contention is that I have gone through in this weekend, I have gone through. My lord, the issue which was raised before this, my lord, issue, my lord, was, my lord, issue raised and discussed and my lord, answered by, I am leaving the single bench, by my lord, 3 division benches, 3 coordinate benches. Now, the first division bench, when the issue was answered in 2007, first division bench, my lord, the answer that, my lord, against the, my lord, the writ petitioners, that they are not entitled to, with regard to the relief claim they are in. Same status, so far the present matters are concerned. So that 2007 division bench matter, after that, my lord, the writ petitioners they are in, they, my lord, carried the matter. They carried the matter to the Supreme Court itself.
Mr. Banerjee, let him come with the list of dates. We hear you then thereafter. It will take some time, Mr. Banerjee.
List of dates is with me right today also.
Oh, it is there?
Yes, I can.
So you will proceed with the appeal?
My lord. List of dates, may I tell you? Just hints, my lord.
No, then we will take it up on another day. We are fixing a date and time.
Lordship can hear me on the two, because to be honest, Lordship can
Our applications are pending. Some applications are there. Since it will take some time, we fix it on that day.
No, the difficulty is this: we are not getting our pensions, in spite of being successful. And to be honest, as per the series of litigations that already been done, and you'll no, please, that's a different aspect of the story. There are kindly, can you allow me to speak? These are the list of candidates already been given benefits after being winning before the Supreme Court, and even some of the candidates have given the benefit only with the trial court's judgment even. That is, it is their choice.
Contempt proceeding was pending, that is why.
It is their choice. Whenever they like somebody, there's an appeal.
Went up to Supreme Court. He is not telling this. Here also matter went up to Supreme
Raising voice will not improve his case. Raising voice will not improve his case. Raising voice, he cannot improve his case. Kindly have a look at this, whatever Lordship has asked me.
But this is outside the court.
We have to look at everything.
You are
on 3 occasions, division bench, coordinate division bench intervened in the matter. The matter went up to the Supreme Court. We have to apply our mind to all these things.
Yes.
We are thinking whether today or any other day.
Yes.
Not that we shall not hear any of you. We shall hear both of you.
No, Mr. Sen, if Mr. Sen, we are unable to understand what is the correct stand of the government.
The correct stand.
Now, if you say on threat of contempt, it has been done.
May I tell? The stand is, Lordship, may I tell? My lord, just, my lord, 5 minutes, Lordship, kindly, my lord, bear with me, my lord. My lord, may I tell? Instead of, my lord, the handing over any list of dates, any document. Now, my lord, so far, that was the first, my lord, the division bench order, my lord, in 2007. the division bench said that, my lord, after setting aside the single bench order and or judgment, whereby it was allowed the prayers of the writ petitioners, similarly circumstanced, the division bench rejected, quashed the single bench order, and matter went up to the Supreme Court. They carried the matter to Supreme Court. Supreme Court, my lord, dismissed the SLP in limine. So that our division bench is concerned, my lord, till, my lord, 2014 or 2015, my lord, that was the, my lord, the order or mother decision remained of the division bench. In 2014, my lord, when the matter was taken up before the division bench in a similar circumstance, writ petitioners, who, my lord, theirs, my lord, also, they, my lord, their petition was allowed, and the authority, they preferred the appeal. Now, when the appeal was taken up by the authority, at that point of time, it appeared that, my lord, in 2014, a memo or GO was issued by the Higher Education Department, totally separate department.
Then what happened?
The university and degree colleges. So far there, my lord, the canteen and mess staff, a policy was laid down with regard to that, but not the polytechnic school colleges, which is, my lord, not under Higher Education Department. Now the division bench says that in view of that policy decision, now, my lord,
Their appointments.
their appointment totally deferred. He said totally deferred from the, my lord.
So then what happened in that appeal?
In that appeal,
appeal was disposed of.
Appeal was, my lord, appeal dismissed.
No.
Yes, with an observation.
With an observation that already whatever they want, that was. Then, my lord, what happened?
Against that, you went up in appeals, SLP.
And again, my lord, in SLP dismissed in limine.
Very good.
SLP dismissed in limine.
So the observation in the second division bench is what?
In the meantime, may I tell? In the meantime, my lord, may I tell? In the meantime, a reference was, my lord, a reference was, my lord, proceeded to the, my lord, the larger bench. Larger bench. Reference, my lord, when the reference, the question was that what relief should be given to them, who are, my lord, the
canteen, what happened? What happened?
Canteen mess employee under the higher education, university degree college. Now, when the reference was taken up, at that point of time, that 2014 circular came up, and the reference court said that no more answer is awaiting, because nothing to be now to be decided, because the petitioners therein, they are satisfied on the basis of that policy laid down by the Higher Education Department.
Very good. Very
so the reference court say that no answer is
understood.
Disposed of.
Yes.
Now the subsequent division bench, which they are relying upon, subsequent division bench. Now the subsequent division bench.
After the reference court.
No, reference court disposed of. Subsequent two benches, my lord, the division bench. In other two matters, here the polytechnic matters, not the higher education. In polytechnic matters, division bench, without looking into number one, in one matter.
Very good. Held against you. Then what happened to the division bench? Or
division bench say that.
Did you prefer go up?
Yes. The division bench said that they are entitled to.
Very good.
They are entitled to
SLP dismissed.
SLP dismissed, and the same division bench almost, because the presiding judge was same. The second matter when went to that, said that almost it has been already decided. So the same, and again the same fate. So for SLP said yes, dismissed.
Then what remains, Mr. Sen?
Remains because of the fact. May I tell? In three matters, SLP dismissed in limine. In 2007 matters, where the authority might
not file any review thereafter.
No. May I tell? Remains. Why remains? May I tell? Kindly give me 2 minutes time. In all the matters, SLP dismissed in limine. That means it was not the merger upwards. The matter remains still, my lord, at the division bench here. In all three matters, when we went to the Supreme Court in 2007, our matter, no, we did not win. The petitioners went there, where we won in the division bench. Their SLP dismissed means that our division bench, what matter the judgment delivered in our favor, that remains. SLP dismissed in limine, my lord knows that is not the marcher upwards. Whatever the division bench said, that remains. It is not the Supreme Court decision. Then in their case also.
So that is your case.
In their case, no, I'm coming. In their case also, twice we went there. SLP dismissed, that means no merger. So the thing remains that one division bench in our favor, contradictory decision by the other division bench in their favor. Then my humble submission, what should be done by your lordship? One division bench in 2007 in our favor, subsequent division bench in their favor, totally contradicting views. Then what should be done right now presently by your lordship when it appears that contradictory views in same issue by two division benches, coordinate bench. And so far Supreme Court is concerned, Supreme Court never interfered.
That list, Mr. Sen, stops when you have the SLP dismissed. And thereafter you did not come and review.
SLP dismissed in their case also.
No, we are not. Suppose, forget about that case. Your challenge has merged with an order of dismissal of SLP. You say that the SLP order, that is a one-line order, no merge.
Yes.
So then, Mr. Sen, the procedure ought to have been, you ought to have filed a review against that order. And if your review would have been dismissed, then second review you could not have filed.
Well, may I tell, lordship?
Now, having not taken such step, Mr. Sen,
there was no need. May I tell? May I tell? May I tell? May I tell?
On the contrary, you have accepted that order.
May I tell?
Passed in their favor.
2007 division bench order was in our favor. Same issue said the writ petitioners were not entitled, thereby setting aside the order of the single judge. Whereby they were allowed.
Mr. Sen, prima facie, Mr.
Now,
Sen,
I shall try to satisfy your lordship.
model employer, they cannot take contradictory stand.
Contradictory stand by the two division bench.
So
And may I tell, another interesting point is that the second division bench said, second time division bench said that 2007 facts are different.
এই শোনো, model employer, you are the model employer. If this way government acts, then we would be constrained to take appropriate steps against the government.
That is the
You have made your endeavor, Mr. Sen. But prima facie, what it appears that there are many questions to be answered. And if we ultimately hold against you, if we ultimately hold against you, Mr. Sen, then consequently the compensation has to be given to benefit these persons. Government cannot file repeated appeals and come with a different plea, Mr. Sen.
The government stand is that why contradictory judgments still prevail by the coordinate bench.
You have acted upon the order.
Acted upon, Mr. Sen.
Yes, there is a contradictory decision in the division bench.
That is why we wanted your assistance. Because you are a reasonable man, you know where to stop and where not to stop.
That is true, but the law.
You are appearing for the government.
And I have already handed over how many persons have already been granted. At least there are 40.
We have extensively heard. Yes, Daku পরেরটা। Wait, Mr. Sen, তুমি যে
It has been granted.
Yes, it was your lordship's direction to come up with the number of the candidates who has been granted.
It will be there. What is the problem?
You keep with it.
Tell us on that.
No, since your lordship,
Did we pass any order to that?
in fact, there's lordship told me verbally.
Let the documents,
Hmm.
let the documents come as filed.
Mr. Bari was appearing in this matter. He was present. He advised me to pray before your lordship a short the accommodation. Kindly let it appear tomorrow, my lord.
Other side case.
I'm for the statement.
Mr. Bari was present, but he just requested me.
That council's presence was required.
Yes.
Council is there.
Council.
আর কথা বলেছিলাম
Council is answering this
এটা
one.
কি ইয়ে ছিল এটা not to be put a
Not to
yes next
Yes.
Number 13.
For the appellant.
I appear on behalf of the state respondent.
state
State respondent.
where is commission? Oh, you are there.
But today I came before your lordship in your lordship's sympathetic jurisdiction. In your lordship's sympathetic jurisdiction. Why, my lord? Why, my lord? The petitioner before your lordship date qualified and having date qualified candidate. Now, my lord, he is supposed to obtain the
18th July order is under challenge.
Yes.
Just give us 2 minutes. কত sympathy দেখাচ্ছে
2001 land was taken on the 2024 malad. I have been given the exempted category certificate, but I crossed the age bar of 2009 land was taken, and in 2024 after the intervention of this honorable court, I obtained the land user certificate. It is 2024, 21st March 2024.
What is your age?
Today I am 46 years and 3 months.
Then what is the relaxed age?
45, because I'm exempted. If I treated to be an exempted category, I'll get
Then
a
it
5
could
years.
be 45.
45.
But you are 45 plus now.
Yes, 1 year, 3 months. as on 1st January 2025.
But by the time you issued receive the certificate, the process was over.
No, Master. I filed the writ petition for 22 recruitment process. Now, 2022 recruitment process is going on, 2024, 5
No, court says that it has already started.
Yes, when I filed the writ petition, at that relevant point of time, 2022 recruitment process was going on.
I see.
Now, today, 2025 recruitment process is going on. And today is the last date for filing online application. I have annexed can you see the last annexure? Page 72. This is 2025 recruitment notification.
But you are age barred, Mr. Ghosh. How can
That's
we
why I came before. First time I said that I came before your lordships.
Yes, Mr. Anything can be done.
Our hands are tight, we cannot allow anybody and
Your hands are tied, but your mouth is still open. So we are asking.
Your lordship, the yesterday's matter also, your lordship, seen the relaxation of upper age limit. We cannot allow anybody beyond the statute is very much clear at 40 is the upper age limit, and in case of reserve category 45. Admittedly 2020 recruitment process, even 2022 recruitment process over.
This is 25
recruitment process.
Prior to this, when was the recruitment process?
Prior to this 2022 recruitment process, 2020 recruitment process.
No, 2022 recruitment process, he got the certificate.
No,
after the recruitment process of 2022.
Exactly,
Yeah. প্রথমে এলো 20-তে চাইতে, ফাইল করছে 24-এ, ফাইল, তারপর 2022-তে সবেতেই চেয়েছে for the purpose of এত
Show us something, Mr. Ghosh. How can we help you?
The rule says that the state government has the authority and power to relax the age. The rule and the notification also says. Will also can you look into the notifications? Page my lord 72. Set of copy text. My lord, age requirement is page 4. My lord, paragraph 4. Minimum eligibility 18 years and maximum 40 years as on 1st day of January 2025. Upper age limit is relaxable for the candidate belonging to SC, ST, OBC, A,
No,
B.
that is usual.
There is no relaxation clause in the
Upper age limit for SC, ST video, that is
Yes.
natural.
And exempted category, I belongs to exempted category.
And there is no
Where is that?
relaxation.
You are saying that relaxation power has been given.
No, there is no clause. In the rules as well as the notification, there is no clause for relaxation.
You found Mr. Bandodar?
My lord, yes. But my lord, before handing over, may I apologize for not being present, my lord. My lord, it was absolutely my fault. Mr. Bhattacharya reminded me yesterday also, my lord. It was absolutely my fault. My lord, I have got the letter, my lord, which is referred to at page 63. But my lord, in spite of looking into it, we could not find the enclosure to this letter, my lord, in our file, which will probably be the more important than this letter. This is the forwarding letter of the Joint Secretary, which is mentioned at page 63. But I find that it has an annexure, which is an email from the high school on 21st of January 2021. Probably the high school will be able to provide the email, which is not in our file, physical file. And since it's of 2021, the records are all maintained in a physical form.
Old mail can be recovered.
Yes. Email can be recovered, but the high school can provide that.
Oh.
We are not having this enclosure at our end.
The recipient cannot recover.
This is approval of appointment of the petitioner. This is the. It was
A copy of mail
No.
from Jara High School dated 21st January 2021. That school must have said that I am forwarding this fake certificate, something like that.
No, but if your lordship takes up page 63 once.
Yes. Top line, Joint Secretary School Education letter of 27 January. That is this letter.
Yes, PD memo number
Such and such.
This office for taking necessary action against Durga Charun Swench.
Of Jara High School, see?
That if my lord kindly give me 1 minute time.
You don't have that?
No, I do not have. It is a communication between the state and school authority.
School and state, yes.
Now, Mr. Bennett, if you are one thing, power is after retirement within 3 years, government can grant permission.
Yes.
So in this case, that period of 3 years are also gone.
Gone.
Now, today, suppose what is troubling us is, today, suppose we dismiss the appeal, then he gets pensionary
He gets
benefit.
pensionary benefit.
But the admission and other documents pertaining to ingenuity of the certificate, that is also on record. So we have to, that cannot, his argument is that issue cannot be diverted from. You have to, but we questioned him that suppose today, if we do not interfere, suppose you also find that it was a fake certificate, then question of recovery will arise. Now that for that board, that recovery can only arise upon conducting a disciplinary proceeding.
And also within the timeline, my lord.
Within the time. So
that is what, my lord, if your lordship sees, I was looking into the impugned order, my lord, if to render any assistance if I could be. Well, that is exactly what weighed with the president of the board kindly sees that if his last line I am reading of Roman 5 at page 64, but after all the other reasons,
yes,
that if his pensionary benefits are withheld and if he moves before the court of law, there is every possibility that the court will decide in his favor. So it is also weighing with the precedent that in spite of these findings, since contemporarily no steps were taken, today even if I stop it, the court will interfere with it and there will be no effect of my order.
He could not have presumed that, no?
No, that is on the basis of that, because within 3 years it was not done.
So this direction itself has been challenged to be without jurisdiction.
My lord.
It is a mere
It's an observation.
Yes, he's apprehensive on the basis of what he has recorded before that.
What is your answer to this? Suppose today we give the benefit to the person concerned. Then you will be accepting the disbursement made on the basis of
here, it has so happened even before we accepting today. Once the order is passed, that is the impugned order. State did not prefer an appeal from that.
Yes, that is what we are wondering.
State has accepted.
So state accepts.
So today it is not an acceptance today. The thing is that by
Your money, na?
May I reply to this?
দাঁড়াও, your money, na? Now our judgment becomes just we are interacting. Suppose we dismiss this vibe will come that court has not seen this thing, that there was an allegation of an that a certificate was fake.
Ingenuine certificate.
Fix it.
The guardian of the finance. Stay very এই যে চিঠিটা, ওই office
দুটোই ফিক্স টিক্স নেই তো আবার?
আমি এটা আনি।
কন্টিনিউ ম্যাটার হিসাবে করে।
নেই তো আজকে। আরেকটা যেটা ওটা তো
দেখি আবার
কমিশন।
জলপাইগুড়ি আছে,
দুটোই 4 নম্বরে।
এখন আবার চাটবে।
4 নম্বর? কি বলেছি? ঠিক আছে, এটা করি।
কালকে যাবে না কন্টিনিউ
Yes.
This item number 4, Lordship wanted Dr. Patro to item number 4 today.
Yes, yes.
সে কি যাবে কালকে?
Huh?
My clients are willing to go tomorrow.
I had a discussion with the chairman. He has requested that if at all they are to go with their offline applications, then on the 16th at 11 o'clock in the morning. Because the 16th, Tuesday, next Tuesday.
Next week.
Very good. Or we are keeping it on 17th then.
Lordships are, there was a circuit bench, Lordships are there.
So whoever will be there, if I am not there, some other person will be there.
This is being, this arrangement is made, at your Lordship's, after that, after hearing me. If your Lordship could,
Now, if he says that 16th will be the date and
So this week we are in difficulty because we are declaring the results of 9-10.
Dr. Bachu will not avoid me. Yes, this is.
if, and after that, your Lordship will be returning after next year, basically.
World is so uncertain. Who can say who will return?
সপ্তাহ হলে এইরকম চলে যাচ্ছে আমরা ভেকেশনে।
Yes, yes, ওটা কি 16th to 17th এ রেখে দিই ওটা।
17th.
Do they need full on? Yes, Dr. Bachu, please look into these.
Yes, yes, yes. No, it will be done, then we will come back. And
No, the comeback for we will give you appropriate. He will not, we will withdraw the petition simply.
Would your Lordship be pleased to mark that item number 4 as part-heard matter?
No, 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 no.
Lordship has heard,
If
extensive.
it is made part-heard, we cannot hear it prior to reopening. You will be now
after reopening.
When the day, when they will, what is the procedure to, when was the last date is over?
Last date is over.
No,
If we
now
give
they
it on
are-
16, if we give it on 16,
Then,
then after next year, in the we will withdraw. Say after
no, I am saying that when is the, what is the stage of the examination?
stage, the date has not yet been declared. They are very
For
much
what?
for written examination. Date has not yet been declared. It is
only the
standing
filling
still
up of forms is complete. We are processing the papers. No schedule has yet been announced.
I see.
So only the form fill up has been completed. That the date was over on 24th September. Only one thing I was saying, if they are to come on 16th, kindly give a direction that they should visit the office. Just this much without
If
record.
your Lordship kindly marks it part-heard. Lordship has heard, in extent.
আরে কি হবে part-heard?
Next year, will come and will যদি চেঞ্জ হয়ে যায় সব করতে পুরো প্রথম থেকে
Upon hearing the learned advocates appearing for the respective parties,
These are the documents which we have sent. But if your lordship kindly takes up the document which just now I have handed over to your lordship. But the interesting part is the incumbent teacher. The incumbent teacher retired on 31st of December. The board president was intimated on 23rd of December.
2020.
Yes, 2020, 31st December 2020, the incumbent retired. Prior to retirement, on 23rd, 8 days prior to his retirement, we have approached the board and mentioned that he has a fake certificate.
23rd of
December 2020.
Where is that copy?
Just now I have handed it to your lordship. First page, 23rd of December 2020. Last paragraph. রাঁচি ইউনিভার্সিটি জানিয়েছেন যে দুর্গাচরণ ঘোষ মহাশয়ের বিএড এর মার্কশিটটি ফোর্জ এন্ড ফেক শ্রী ঘোষ
Where is that Ranchi University letter?
I have given to your lordship. The fresh copy, it is also annexed here. Third page. Forged and fake. Exactly this word has been mentioned. The fresh copy has been given to your lordship.
Yes.
Single copy. Remark is fake, controller of examination. Now, my lord kindly turns to the next page. 17, that batch, just now, which I have handed over. On 17th of December 2020, once again we approached the president of the board, along with the principal secretary of the education department, commissioner. Same thing.
Where is that?
Next page, page 2. Second page. Just now the copy that I have handed over.
Yes.
Same prayer, but at the Ranchi University has said.
President of the board on 23rd December.
Yes, and 17th December also.
17 December was to the president again.
Again.
The headmaster only. The managing committee by adopting.
No, the headmaster has sent it.
Managing committee by adopting any resolution.
Yes, yes. Malad, I am the secretary of the managing committee. Headmaster.
Maybe. Why?
No, I am the secretary of the managing committee has no role to play. I have forwarded the papers to the department. The president is the authority to take the disciplinary.
Decision was taken by the managing committee to pursue these remedies.
But that I have to take instruction.
Yes, so 23rd December 2020, 17 December
2020, we have gone to the officer board.
Yes.
Then your lordship turns to the last page. Even
last page.
Yes. Last but one page. But 14th of October 2020.
Yes.
We have also approached the office of the district inspector, and we have said that the qualification and the certificate of the BEd is not valid. আমার কি করণীয় সেটা আমাকে জানান। And all these documents were sent to the department by mail. The next page, last page is the mail, which Mr. Banerjee has handed over the copy of the mail dated 21st of January 2021.
What is your contention here? Kindly come to third paragraph. This does not tally with your explanation in the first representation.
Me?
Yes, উনি ওনার
it was on
সময় অবৈধ বিএড কোয়ালিফিকেশন দেখিয়ে ইন্টারভিউ দিয়েছেন এবং ইন্টারভিউ সময় অবৈধ মার্কশিট ইন্টারভিউ করতে জমা দেন। পরে ওনার চাকরির বিষয়ে হাইকোর্টেতে কেস হলে পুনরায় হাইকোর্ট এই অবৈধ বিএড এর মার্কশিট জমা দেন এবং হাইকোর্ট থেকে ডিগ্রি লাভ করে মাননীয় ডিআই এর অনুমোদন করে চাকুরিতে যোগদান করেন। সো ইয়োর নলেজ অন দি ডেট অফ সাচ application for appointment was with you, and you say that the High Court directed to give the appointment. So why didn't you prefer appeal against that order?
Well, I tell your lordship. But kindly read this.
That order is as annexed at the page.
High Court's order?
Yes, that is annexed here.
Single man panel.
Yes, very good. That is page 43.
Yes, what High Court has said.
Yes, you show us what's High Court. It is a longish order from page 39.
I'm reading the,
This is the order, no?
yes, 44. Internal page 6.
Yeah, just a moment. Qualification for the post was not B.Ed. Qualification was M.A. Bengali with Sanskrit. Decision to approve the panel. Achha. Appealed against by the school. Division manager considering final directed to BI on the basis. Yeah, just give us 2 minutes. Yes. Yes, yes. In that there was no allegation leveled.
No,
you B.Ed qualification was immaterial for the post he was taking appointment.
No.
Yes, page 39. The
Page 39.
M.A. Bengali with Sanskrit.
Yes, qualification required by the school authority was as follows: M.A. Bengali with Sanskrit at degree level and preferably trained. Yes, he must have a trained qualification. Now, if
that qualification preferably trained.
Yes.
So without training candidate also can be considered.
Number what he has now
was the only applicant.
He was the only applicant.
So question of weightage to B.Ed does not arise.
Now kindly turns to the next page, page 47. Yes, page 47. He was a Bengali teacher, language group, and his approval of his appointment was done as M.A. Bengali B.Ed with Sanskrit at degree level.
His B.Ed qualification was not mentioned in the approval.
Yes, his approval. Yes, page 47.
Yes.
M.A. Bengali B.Ed.
B.Ed.
It is there, and he was drawing B.Ed scale. Now,
Mr. Bhattacharya, what were you doing?
Your Lordship,
2001.
The answer is here, but I'm giving the answer.
Yes.
Kindly give me 1 minute time.
Yes.
Page 58. Serial 7. This is the report of the DI to the board regarding the disciplinary proceeding.
Yes.
Serial 7. The fact was appeared in the limelight and enlisted with the suspicion when C. Ghosh was repeatedly asked.
Where was the suspicion, Mr. Bhattacharya, at the time of appointment? It is not that it was a plain and simple appointment. It was scrutinized by 2 courts, 2 single benches and 1 division bench. Never you have taken this objection. You may argue that it is not known to me. But it is not known to you if you had any suspicion from 2021 till 2020 till cessation of relationship, you will not do anything.
But the answer is here.
Answer is just 1 week prior to that you level this allegation.
No.
Yes, 23rd December is your representation to the board.
But kindly,
how do you justify your stand, Mr.
kindly turns to page 7, serial 7. Kindly have a look to once.
Yes,
But
yes.
I'm not defending anything. But I'm here to.
You're exactly defending. It is not your money, it is state money.
Yes.
Now you are certainly become overconscious about this fact that how a fake certificate benefit can be taken away in my existence. I'm the headmaster.
No. Well, kindly don't take it in that fashion. Kindly turns to page, but kindly read.
Why you are objecting so much to this? You have filed an independent writ petition challenging the disciplinary proceedings. State has not come.
No, I have not filed.
This appeal.
Appeal.
You have taken the stand in the appeal.
Well, I have taken the stand in the appeal on a very different point. Whether
it is without jurisdiction or
yes.
Not. Yes. Will deal.
Your lordship, kindly have a look to serial 7 once. Kindly, for my satisfaction, kindly.
It's 2024.
Who is writing?
The memo, yes, district inspector.
I have
his memo
his
so
retirement.
So that this fact unearthed for the first time in 2020.
No. It is the board who has taken 4 years to take the initiative.
Show us one document that you took step to find out whether it is fake or genuine. Your one document.
But the answer is here. Kindly read serial 7 for my satisfaction.
Yes, you read.
Please allow me. The fact. Well, then I'm reading from serial number 1. It will be better. The fact of respective school management committee was the then prepared one-man panel for the appointment for the post said post with bidding. Then panel preparing authority was being the competent authority to verify relevant documents to ensure the fulfillment of eligibility criteria of the candidate appearing for the post. The one-man panel was also drawn a legal question and was disposed of by the Honorable Court. Subsequently, the school authority had issued appointment letter to the candidate and candidate has joined the post. On the basis of the joining report and other relevant documents, accompanied with recommendation of MC, this office has issued approval of appointment in favor of the teacher in question. Then, on the basis of the approval, the monthly salary has been released. Then, the fact was appeared in the limelight and enlisted in the suspicion when Sri Ghosh was repeatedly asked by the then headmaster to produce the original pass certificate of B.Ed degree before preparation of the respective teacher's service book. But Sri Ghosh failed to produce the same, or maybe he deliberately avoided to confront the uneasy situation. Then,
and this you can prove. This clause 7, we are asking for a representation from you that you raise this query much prior to in the midst of his service career. When did you join as headmaster? You must have joined just prior to his retirement.
No.
Then when did he join as headmaster? You will not.
When you join.
No. Then I have to ask that. May I go back and
you don't know.
But the question suddenly come. May I go out and just give a phone call to him? Because when I joined,
you also do not know when did your headmaster join. You are having consultation with your client. Take up the matter. You don't know the facts you are now raising. Yes.
Then 8.
Ascertain. Go outside, ring him up and ascertain just now. Incorrigible persons. Yes. Yes.
Kindly give me 1 second time.
Next, what you want to show?
At that time, Sri Ghosh may confess his guilt. In spite of that, he has pushed the school authority to the darkness without producing the original B.Ed pass certificate. And at last, on the verge of retirement, Sri Ghosh produced the B.Ed certificate on 14th July 2020 before the school authority. The teacher produced it in July. Then, the school authority has sent this certificate to the concerned university for its verification. Well, we were not aware that whether it is genuine or fake. Then the concerned authority has sent the verification report on 17th of December 2020 regarding B.Ed degree certificate in respect of Durga Charan Ghosh as fake. Then, under these circumstances, this office solicited your kind instruction before processing the file of retirement benefits so and so. This was placed before the board. We approached the board in 2020 because this original document of B.Ed was never given to us. The moment it was given to us, the school of management has made a query to the Ranchi University. The Ranchi University
2007 headmaster.
But he was an approved teacher. How do I know that whether his certificate is fake or not? Nobody has raised any question.
Yes.
At the time of preparation of service book, this has come. This point has come. Please bring the original.
Anyone? Rule 5.
Got it? That will be helpful.
Mr.
Ghosh Chaudhary.
দুটো না একটা কপি তো ঠিক আছে জোসেফকে তো
2 copy, I have 2 copy.
2 copies.
It is hard to handle.
Every day we are handling.
Maybe extend it to this to condition
Kindly see first proviso.
After 3 years. Ekhane it has been
Rule 5(3), first proviso.
So for the initiation of disciplinary proceeding, first memo is page 61.
First memo is page, yes. No. No.
59, show cause issued. First show cause issued.
59.
59. On basis of the report of the DI. Sorry.
Now, before that, the DI was it was intimated. Remind.
Initiated after 3 years from the date of alleged misconduct. Detained inspector in service. পরবর্তী সেকেন্ড প্রভাইশন রেসপেক্ট ডিটেল
সে তো ওরিট পিটিশন আমার কাছে
পিটিশন মানে রিলেশন মে উইথ দ্য অ্যাপ্রুভাল অফ দ্য 3 years from the date of the
Within 3 years. That is
Maybe-
exactly
maybe
being done.
Initiated.
Initiate.
My lord, this is a
4th of
reminder.
October. 4th of October 2024. This is a reminder.
Reminder to show cause. My lord, what is the-
23rd August 2021.
23rd.
Your Lordship,
Yes.
page 52, first line, a show cause letter was issued on 23rd August 2021.
52.
Page 52, first line. That is a reminder. 59, I'm sorry.
59.
59. The handwriting is not.
23rd.
23rd August 2021.
And you gave permission for initiation on 27 January 2021. Page 64, clause 2. Your permission to take action.
The alleged misconduct became known to the board. কখনো বোর্ডের কাছে ইয়ে করা
বোর্ডের কাছে তো শোকজ দিলেও তো বসে
2021
The school education directorate does not have any power to grant permission.
Only to extend the time.
2020.
Permission is not
So 3
permission after 3 years.
after
5-3.
this provision. কিন্তু 3 years হলে করতে পারছে না এবার মানে
Period maybe.
First provision.
Retirement intervene.
শোকজটা হয়েছে
Alleged
Board is within.
becomes known to them. In service. In
Initiated.
service. Then he is in service. Before
Effect.
December, alleged misconduct becomes known to the board. So disciplinary proceedings could have been initiated within 3 years.
It has been done.
Shall be initiated. Here it could not be because date of retirement intervened.
Date of retirement 31st December 2020. পারমিশন দিল প্রসিডিং করতে জুলাই 2021 জানুয়ারি 2020 তখন শোকজ
না দিদি পরেরটা পড়ছে
পরেরটা কেন হবে আগে
আফটার রিটায়ারমেন্ট
প্রথম আফটার রিটায়ারমেন্টের প্রথম প্রোভাইসরটা পড়ো ফার্স্ট প্রোভাইসরটা
পড়েছি আমরা
হ্যাঁ
আমরা পুরোটা পড়ে নিচ্ছি একসঙ্গে
নিয়ে বসেছিল May with the approval of the B instituted within 3 years, that has been done.
টাকা দিবি
ওটাই তো আমরা বিপদে ফেলে দিচ্ছি
আমরা সাবমিশন অফ দ্য চার্জ
21 বছরের মানে ডিএর টাকা
My lord, after this, so far, my lord, the petitioner, my lord, at page 60 have written a letter to us. Page 60.
He admitted that it's a fake certificate.
Thereafter, my lord, a hearing was conducted. Both gave hearing to the petitioner and school authority, DI and all. Thereafter, my lord, this order was passed. Where, my lord, the main contention of board is that at the he was appointed in 2001. Neither the school authority, neither the DI, nobody checked about this document and all. Now, after retirement, he retired in 2020. Just 1 week before his retirement, my lord, the letter reached the board. So, my lord, the contention of board is that he has taken his service. Now, you cannot deprive him from his retirement benefits. So, my lord, what will be the amount? Whether he will get the payment as
When the person says I have produced a fake certificate, thereafter also you will not issue a charge sheet.
Well, board has decided, lordship, to
How? You are a statutory authority.
he has retired, my lord.
So may have retired. After retirement, 3 years permission is there. If state gives permission, you can initiate. You sit in your office and say that, oh, no use going on with this. And what is your consequence? It is hereby noted DCMA procedure if already initiated. Your rule says that upon issuance of charge sheet, the proceeding gets initiated.
No, charge sheet not.
So there was no initiation of the proceeding.
No initiation. Only
Why? Why? What is the reason? Because they did not take steps, I will also not take step.
That answer I don't have, but my lord, what?
That answer you don't have. You are right. That is why the order you have passed without any answer to the issue.
You come to page 64, clause Roman 2, last line. Basically, state government accorded permission. Proceed, but you have not proceeded.
His degree is fake. So, my lord, the salary
Madam,
is
don't
of-
add to the reasons. Don't add to the reasons. You are a lawyer. You are not the board disciplinary authority. Yes, Mr. Bandyopadhyay, what do you say?
Mulad, I can only assist the court to the extent that if we read the proviso, they were within the time to initiate, because it says 3 years not from the misconduct. The misconduct, there may be a debate where it was at the time of interview or at the time of filing the papers for the retirement benefits. It is from the misconduct is known to the board. Misconduct is known to the board at the earliest on 17 December when this letter which is produced, second page. So he had time for 3 years from that time. So Malad, that part of the reasoning, Malad, is probably not in tune with the rules. So Malad, it can be sent back to the board, Malad, to deeming this time, Malad, not to have elapsed, but from that time to initiate the proceeding, Malad. Because I'll tell you, Lordship, Malad, where the order is lacking, Malad, in my humble understanding. He says that in paragraph Roman 5 at page 64, to initiate, I'm reading in the middle of that paragraph, longish paragraph. So and so rules 2018 to initiate discipline proceeding against him within 3 years from the date of his retirement, but with the approval of the state government. He has gone to the second proviso at the inception, leaving aside the first proviso. First proviso, when it applies, person was not retired. Person retired on 31st of December 2020. So he got the information on 17 December 2020 before he retired. So he is in the first proviso stage. In the first proviso stage, he can initiate proceeding from date of his knowledge.
Second proviso is not applicable to him.
If it is after retirement, second proviso is after retirement.
Second proviso after.
So Malad kindly relates it back to the date. What very important date? 17 December 2020. That is the letter submitted by Mr. Bhattacharya. Well, I am not trying to argue in favor or against the board, Malad, but I am only trying to give a meaning to the two provisos in my understanding. What the authority has written here is probably not correct. That 3 years from retirement.
Before cessation of relationship, the allegation was made. prior to retirement. So board, it came to board's knowledge prior to his retirement.
So first proviso will apply.
You have to conjointly read it. First proviso is satisfied in respect of persons who are in service.
Yes.
And second proviso is pertaining to persons who have retired. You gave the permission to proceed with the disciplinary proceeding after his retirement.
No, Malad,
Your memo was 20th July 2021.
Malad, I am trying to argue. Malad, kindly Malad comes to the proviso. First proviso.
First proviso from the date of
Provided that
information.
no disciplinary proceeding shall be initiated after 3 years from the date of alleged misconduct become known to the board. However, the said period may be extended with the approval of the state government.
Right.
So this is required when the period is to be extended, not to initiate, only to extend the period. Now kindly take the second proviso. Kindly see the
Just a moment.
answer.
Said period may be extended with the approval of the appropriate authority. That
Not-
means in service.
Not to initiate, only to extend the 3 years. In the
Yes.
Now kindly take
So
the
that you can initiate the proceeding in terms of the proviso.
if it is after 3 years.
Uh-huh.
If it is within 3 years, it is not required. This permission is not required.
Yes.
Then kindly take the next proviso. Kindly see the difference in language. Provided further that in case of retired teaching and non-teaching staff, disciplinary proceeding with the approval of the state government may be instituted within 3 years from the date of retirement if the misconduct becomes known to the board after retirement. So if he has already retired, then prior permission of the government is required.
Yes, because charge sheet is
To initiate. In the first proviso, to initiate permission is not required. To initiate after 3 years, permission is required. And in second proviso, to initiate permission is required. And for extension of 3 years, no permission is contemplated at all. Therefore, I say that date 17 December is important. When it is coming to the knowledge of the board, the person was falling in the bracket of first proviso. He could have initiated then and there itself.
No, Malay, we have done. After getting the information, Malay, we have asked the DI to hold a preliminary inquiry, Malay, page 58. That is the reply of the report of the DI, where it reflects that we have asked the DI to hold preliminary inquiry in month of February 2021.
But ultimately the charge sheet was not issued. So that period of 3 years have gone from the date of retirement.
No, we have asked.
We have taken a decision that no charge sheet is required.
Yes. But Malay, the period, my lord, we have asked the DI to hold preliminary inquiry, your lordship.
বিলটা প্রমাণিত হচ্ছে আমি চার্জশিট করবো কিন্তু আমি দিতে পারছি না যেহেতু 3 বছর ওভার হয়ে গেছে
In my understanding, if all the parties are put back to the situation of 17th of December 2020, when the intimation went to the board, because for whatever reasons the interpretation has given to the rules, that is not right. That and on the face of it, it is not right. None of the facts are needed to be gone into.
Provisos have not been referred to here.
Yes, no, Malad, when he records this particular sentence, it is in Malad, derogation of the rules. To initiate disciplinary proceedings against him within 3 years from the date of his retirement. This is what he is misconstruing.
Where is
Malad, in 64, Roman 5, in the middle of Roman 5, rules 2018, to initiate disciplinary proceeding against him within 3 years from the date of his retirement, but with the approval of the government. I say
that is the argument of the learned advocate. Further, according to the learned advocate, there is no bar vide rule 5.3 of the such and such rules to initiate proceeding against him within 3 years from the date of retirement.
Yes,
Which you are saying wrong.
Yeah, then he says that the entire liability cannot be thrown alone on the shoulder of the teacher. The concerned school authority as well as DI concerned are equally responsible, as without verifying the genuinity of certificate, they allowed him to work as assistant teacher. Well, this is immaterial for him. What is material for him was when he, as a board, as the authority of the board, when it was brought to his knowledge, he should have construed that part only.
to your arguments, then the person will go on without pension.
Yes, my lord, it is not a case where the equitable considerations outweigh the impact on the state. It is a case where he has brought up
all his pension.
Yeah, my lord, admitted case is that he is admitting that there is a fake certificate. He says, I did not have knowledge that my college was affiliated to the university.
He didn't say it's a fake certificate. He said that it was not having affiliation. He said it is fake.
My lord,
Where is that letter?
yes, page 60, my lord.
Is not valid.
It is
Not valid. Not valid. He didn't say fake.
Because the college from where I obtained the qualification was not affiliated
to the university.
To the university. By the university.
We were the Ranchi University.
However, my lord, the DI's finding is that it is forged and fake. Fake.
এটা কি করে রাঁচি এটা করলো ওটা অ্যাফিলিয়েশন থেকে কলেজ দিতে পারবে What you have done?
I have a little submission.
Well, only one thing.
I have a little submission, madam. I have completed. I hope everybody completed. I have a little submission. But in 1985, with a good hope that the college is affiliated by the university, I got admission in the B.Ed college. But I candidate.
Right. If you have been affiliate, answer us. If you have been affiliate, your college was not having affiliation.
Yes.
Right. But you sat in the exam.
Yes.
So you were allowed to sit in the exam by Ranchi University, though the college is not affiliated.
My lord, this is the this was going on, my lord.
Then there is suspicion as regards.
Yes, my lord, I am not on that point. My lord, I am on that point, my lord. Subsequently, my lord, 2001, I got admission. I got appointment. My lord, at that time, 2001, I handed over the entire original document to the school authority. Right, my lord?
They did not do it.
They did not.
How do you come out of this issue?
Yes.
Fake certificate.
Fake certificate, my lord. Subsequently, it has and vital point is, my lord, board's order. Neither party has challenged the board order.
Very good. So if it is not challenged, your fakeness goes.
No, my lord, I am not on that point. I am only that point, my lord. If my learned Mr. Bhattacharya's client such any grievance, they should come forward, my lord. When, my lord, after board's order, I filed a writ application that I am facing some starvation. I am living without any penny, or not a single rupees has been disbursed. I am in starvation. Allow me at least disburse the amount, some amount.
They will
at this juncture, my lord, they have come out and they
will give you provisional pension.
That, my lord,
we will direct that you pay provisional pension. And show us under the DCRB scheme, gratuity along with provisional pension, how much percentage of gratuity you will get. I think 90% can be disbursed. এই হেডমাস্টার ম্যানুয়ালটা দাও দুটাতে হবে না তো ইচ্ছে করছে না
and my lord, no police case has been filed. No criminal case has still now, no criminal case has been. Who has committed the wrong? My lord, actually, it should be determined by the proper.
We are asking you a simple question. How do you place above this contention that this certificate, college not affiliated, we understand. Then it may not be a fake certificate. Yes. But if the college is not affiliated, how did you appear in the exam? How
did at that relevant point of time affiliation was?
Where from you are making this story? At the relevant time there was affiliation.
Consequently, this is my base knowledge.
Your contention. Please show.
So at that time there was affiliation, subsequently de-affiliation. So subsequently it is de-affiliation will not invalidate the certificate issued when affiliation was there.
When affiliation there, if this was you don't know your own story, your client has not disbursed everything to you. Mr. Ghosh Chaudhary, you have to overcome this stigma of fakeness.
Yes. That.
Otherwise, court says that in case there is existence of any proceeding, you will not get the full pension. Provisional pension you will get.
But neither party, but when the boards come out with an order, neither party has challenged that order.
Suppose admitting it has not said. Now it has come to us. When it has been come to us, repeatedly it is being pointed out to us, fake certificate, fake certificate, fake certificate. Board's reasoning is, since the other authorities did not do, at the fag end of your life, you are being faced with this allegation. That also we could have negated. But how do you bring yourself out of this stigma? Then show us that when 1985, this contains a date is there. This is a Ranchi University certificate. Then your college must have been affiliated at that time. Then show us anything so that it can be reasoned out. Without that, how can we help you? Tell us. And go through DCRB. I think DCRB provisional pension will be that is during pendency of disciplinary proceeding. You will get 28 something. DCRB. Disciplinary রুলটাতে পেনশনের কিছু থাকবে না। In your discipline, in your rules, is there any provision for provisional pension payment, etc.? In your rules? I don't think it is there.
It is in the DCRB.
No, we don't.
Pension. ওটা কত আছে?
Here is
প্রগতি আছে।
DCRB.
এইখানটাই
Yes. Final pension shall not be sanctioned during proceeding in case misconduct or withhold pension or reduced. The department was continued against the employee who is retired on active circumstances. He will be taken confirmation final orders as a provisional pension not exceeding
maximum
pension. No, it's a gratuity part. No gratuity or DCRB beneficiary.
Gratuity দেব।
No, it is a it's only one or more.
RTI information that I needs to seek information under section 5 that whether that time that college is affiliated or not by the just like that way Mr. Bhattacharya's clients obtain whether the certificate is fake or not. Otherwise, my lord, authenticity is this document. Based on this document, I believe that it is absolutely all right. My lord, kindly visualize my situation.
You have yourself said.
Yes, that declaration, everything was fine, going on smoothly, but after at the time of retirement, that dispute cropped up. And I was waiting that with the verdict of the board. When the board discharged me, my lord, I filed a writ application.
Mr. Chaudhary, you remove our doubt. You remove our doubt to give an appropriate order. We are in judicial review.
Lordship. I.
With a doubt in mind, we
Yes,
will not do something. Now, suspicion again is howsoever high, it is not proof. At least you can.
My lord,
Your statement, DI's letter, DI in his letter says that you have confessed your guilt.
My lord, may I suggest only one thing? Past and interim order, provisional pension be allowed in favor. And in the meantime, my lord, I will try to gather the better information whether that time after the matter come out the hearing, give me an opportunity of opposition. My lord, give me an opportunity to file an opposition, my lord. I will contest this. No, my lord, I'll subject to correction. In my mind, it is going on that if I filed any RTI application before the Ranchi University, whether at that relevant point of time that particular college is affiliated or not, everything will clear. It will up 30 days, my lord, since his client is obtaining information, I believe I will also get the information. Since the authority is responding. If something is there, I will come up with an opposition, my lord, and contest this appeal, and kindly pass an interim order that I can survive. That much I am at this stage. I am that much I can pay. At best, my lord, at best, what situation my incremental BEd respect of since the post is concerned is a master degree, my lord, that I am holding double level. There is no doubt, there is no dispute. I am double level from the Calcutta University and Bardhaman University. There is no dispute at all from my learned friend also. His objection only respect of BEd. I can overcome these difficulties, and I will contest it accordingly, my lord, by filing an opposition. But at this stage, my lord, I am very difficult to survive. My lord, 5 years have passed without any. He is not. 41.
For the time being, as your argument has to be made.
Yes, my lord, but my lord, kindly do not keep it pending, my lord. My lord, kindly, my lord, relegate the parties back to that position.
Set aside the order then.
Yes, my lord, kindly set it aside and send it back to the authorities, giving liberty to the board to proceed from that stage, from where the knowledge emanated. Because my lord, there is another difficulty, my lord, which is coming to. I'm trying to assist the your lordships, my lord, that the present appellant did not challenge the board's order also.
No. When he came for the implementation of the order.
Then, as if it is his writ petition, in the appeal, these points are being taken, maybe valid points. But the question comes to my mind also why they did not challenge the board's order by themselves. But be that as it may, my lord, now, my lord, as apropos to what is falling from your lordship, my lord, this factual aspect can only be dealt with by the board. Well, kindly relegate the parties to the position of 17 December. What they should have done from the date of knowledge.
No, my lord, from the date of.
In judicial review, my lord, this procedural impropriety, my lord, your lordships are having the power to erase. My lord, kindly erases this part up to 17 December and kindly relegate the parties to that. In the meantime, kindly give them a time within which they should complete it, my lord, since considerable time has elapsed. In the meantime, we'll pay provisional pension to them.
No, but how can we direct the board now that you issue a charge sheet?
No.
Board has already.
Well, I'm not saying so. Well, I'm not saying so, my lord. What I'm saying, your lordship may direct them to proceed from that stage, my lord. If it commences to them to go to 5 sub-rule 4 to issue the charge sheet, they have not complied 5.3. So the question of 5.4 does not come. Their interpretation of 5.3 itself is wrong.
No.
That is not their interpretation, it is their submission of the.
Set aside. In that case, my lord, board's order liable to set aside. If the
Yes.
yes, my lord, demand is back to the.
Yes,
Otherwise,
it has to be. It has to be. Then it is in conflict of the other order. It says B.Ed is compulsory also.
I am ready to face the opposition, my lord.
অপোজিশন করে কি হবে?
আমি তোমাকে কন্টেস্ট করবো না, আমার লিখিত করে আমার বক্তব্য দেবো না, আমার তো রাইটটা চলে যাচ্ছে।
Your writ petition will be treated as your
It is his writ petition.
But only one prayer. Regarding no, I will not take more than 1 minute. But
No, not about you. Because it is not your writ petition
no,
also.
not my writ petition.
Then how do you sustain your stand?
Yeah,
How do you sustain your stand?
after 4 days of argument.
Don't
No.
say something immaterial.
But I tell you.
We are taking a decision on a life of a person.
Absolutely.
So don't make immaterial submission. After 4 hours, 4 days, I will not get an interim order. On that ground itself, we have to be thrown out.
But
Take the court in that manner.
No. But never.
I will hear. I have a right to deliver justice here. So people will not command that you hear it for 5 minutes and deliver the judgment. Be cautious in your submissions.
But I never said.
You don't know the effect and you are making an argument. You are quite senior now.
But I have argued this.
What sort of an argument is this? I have argued 4 days. I am entitled to interim order.
But I'm not on interim order. Your lordship said that what is in reply. But this point on the very first day was argued by me. That when I have not filed the writ petition, but what is my defense in appeal? But my defense in appeal is twofold. First is whether rule 5, kindly see rule 3 of the 2018 rules. This was the argument I placed before the Honorable Single Bench. That whether the board has the power to direct the district inspector to pass the order of releasing the pension. Whether it is within the domain of the board or not. That was my argument. This was considered and rejected. And second is the admission of fake certificate. The petitioner himself has admitted that it's a.
Where is that admission of fake certificate by the school by the petitioner?
Page 60, can you have it? My B.Ed qualification was not valid because the college from where I obtained the qualification was not affiliated by the university that time. the college which was not affiliated at all, but if I get a certificate from that college, it itself is fake.
For that, you should have challenged the order.
But I am the school. Absolutely, it is absolutely true. But I am the school, but I have to take care of so many things to approach the court.
No, why?
No, but I have to, first of all, but I cannot.
The headmaster, you have not even placed the resolution of the managing committee. That it is the decision of the managing committee to prepare this appeal.
Yes. Kindly give me 1 day time. I will place it. This point was never taken.
1 day time.
But the point suddenly, if the question,
if say that
I have
school authority
not be ready.
Absolutely, I am ready.
The
But I have
managing
preferred the
committee,
appeal.
Mr. Bhattacharya, managing committee has authorized you to prepare this appeal.
Absolutely.
Have you shown it? So that managing committee has authorized by adopting a resolution.
Give me 1 second time. Follow resolution. I have the resolution. Before preferring the appeal, I have taken care of all these questions.
But you have not taken any decision to challenge the decision of the board.
No. I have not. But we have approached.
Come and show us that there was any resolution to challenge the decision of the board.
Decision of the board?
Yes.
But no. That is here and now. I have not challenged it, but the decision. But it is not my money. It is the state's money.
State is not happy with that.
What is your personal?
I have no personal enmity with anybody. But person will be taking.
What is your injury? Legal or personal injury?
A person will be having a fake certificate. He will draw the.
For that you have to take a decision to challenge. It is not.
But I have to. Very well. Kindly give me 1 minute time to answer. But I am only the headmaster, being the secretary of the managing committee. I have to take the consent of the president, 13 members of the managing committee. I will definitely to prefer the appeal. I have taken the consent of the managing committee. That is why I am for your
extensively heard the learned advocates appearing for the respective parties.
the appeal to prefer the writ petition.
Oh, I see.
Next, item number 14.
Swapun Banerjee is appearing for the state in this matter, my lord. I'm praying for a pass over, my lord. He's engaged
for the state. I'm for the restaurant, my lord. State, no? My lord, I'm for...
Not today.
Huh? Not today.
Where is your counsel? He's
Well,
coming just now.
Well, he was here, my
He's
lord.
engaged in courtroom number 5, my lord.
You start. What is the matter?
That matter, my lord, regarding delay, my lord. Delay.
The last
Not
occasion I
this week, not this week. Yes, next.
not this week.
Next, ওইটা কবে রেখেছো ওই ডিলের ওই মামলা
The order may come up.
হ্যাঁ
Supreme Court order may come up.
Yes, next. Supreme Court order for what?
This is that issue. The matter is pending before the Honorable Supreme Court, and the Honorable Supreme Court has stayed. Your Lordship has also held in other matters. The Honorable Supreme Court has stayed. For that's why your Lordship has stayed the matter for limited period or up to the date of the order which the Supreme Court will pass in order, whichever is earlier. That was your Lordship's order, my lord. And in this
So today it has come up for what?
Section 5.
section, your Lordship was inclined to decide the section 5 first because there is not sufficient explanation there. We raised this point, we filed the opposition. The exchange of opposition there.
Are complete. Very
So in the meantime, your
Section
Lordship,
5.
next week.
Next Thursday it will be there. Yes.
Next Thursday.
Next Thursday. দেরি আছে।
হেজিটেট করে ফেলছিলাম কেন
The direction to file affidavit in opposition, my lord. But we have received the, my lord, the instruction and the papers, my lord, yesterday. But 1 week time to be given, my lord, to file affidavit.
Have you deposited the cost?
It is stayed.
Eh?
It is stayed.
No, we
Cost 10,000.
10,000. It was last order, it has stay the cost. জমা দিয়েছো কি সেটা my lord?
Oh, last order stay করে দিয়েছে।
that cost.
Cost
Oh,
of the
that
state,
cost
DSO.
payment we have stayed. Acha.
And also directed to service the non-appearance respondent. This
Oh,
affidavit. With the
Affidavit of service, as filed, be kept on record. your contention that after we pass, Mr. Advocate, please look at us. Is it your contention that after we pass the order in appeal, you have not been allowed to enter the school? Is that your contention? Then what is your what you are wanting from us?
Approval of the petition.
Approval, that is the subject matter of appeal. But you are saying I want an interim order. What interim order you want? We have granted you an interim order, staying the operation of the direction of payment of cost. What you have not prayed for any other order. Affidavit of service as filed be kept on record.
My lord,
Please, your lordship, I am for the petitioner appeal matter.
ও তাহলে কি হাওয়া থেকে এলো? বলতে বলতে না এটা কন্ট্রোল।
my lord, in this matter, Mr. Joydeep Banerjee's new appointment for in place of Mr. Bishobrata Basumolli. Kindly allow 2 weeks time, my lord.
The lordship was pleased to direct them to file the affidavit of
Yes, my lord.
opposition. Till date, they did not.
No, my lord, due
On
to
15th September, my lord, order was passed.
yes, my lord, drafting is ready, but due to depanelment of Mr. Basumalli,
When you will file, tell us.
My lord, kindly accommodate 2 weeks time.
2 weeks will take you beyond the vacation, na? File it within a week.
My lord.
Then we are keeping it on 22nd. In the meantime, you file your opposition, give a copy to him so that he can also file a reply.
My lord.
22nd. File it. Positively file it by 16th or 18th. You file, you are getting time. And then. Yes.
My lord, item number 17, my lord. Yes, my lord, my appeal, I am appearing for the University of Kollani, my lord. My lord, last occasion when the matter was taken up by your lordship, my lord, it was found that state filed one report in this matter and petitioner prayed for some time to file the counter of that report. My lord, accordingly, my lord.
The direction, my lord, to file an exception to the report filed by the state.
Yes,
my lord. It's ready, my lord. I'm filing it.
My lord, we have not received any copy
Today
of.
we have affirmed it, my lord. We are circulating right now.
You are for one respond. Oh, you are the read petition.
Yes, ma'am.
Respondent number 1 and 2.
You have filed an exception as directed.
Yes.
Then it will go beyond the vacation.
Well, a very short point involved. If your lordship, my lord, kindly keeps it in the next week, my lord, we shall come back. Subject to your lordship's convenience, my lord.
Whatever, you have not given him.
Just now I have received.
My lord, I have affirmed it, my lord. That is written.
Kindly keep it after vacation, long pending matter, my lord.
Mr. Haldar learned advocate appearing for the
Item number 18.
And for the state, my lord. Page.
Order under appeal, my lord, page 61. In my stay, my lord, application for appeal. Page 61.
This has to be heard. Writ petition was decided.
No,
on
last,
immediate.
my lord, last occasion, my lord wanted to know, my lord, the director, my lord, this is one of the non-relevant subject.
Kindly, Mr.
5 years.
This one thing is, this is totally this page 62.
Page 62.
Fourth line, it is also the case of the petitioner. You have got it,
My lord.
Mr. Ali? It is also the case since he was taking more than 6 classes per week in English.
Yes.
In terms of circular of 27 November.
Yes.
Is entitled, this is not subject to this 27. These 6 classes were given you without prior permission from the DI. There is a judgment of our Honorable Justice Baring Ghosh on this issue, that subject to correction, if that without permission you cannot be given those additional duty.
But my lord,
Check up
with the permission of the school also, my lord, for the time being arrangement, according to memo, my lord, 27 January 1995.
Where is that
the
memo?
school have the power.
Where is the memo?
Where is that memo? Have you annexed?
ওটাতে দেখুন আছে with the prior permission of DI.
My lord. That has been quoted also. But my lord, it is a non-relevant subject. My lord, according to my lord,
Non-relevant survey ROPA after 5 years they are entitled.
The memo is there. My lord,
We asked you that thing. But so we told you. We told you that do you know? আমরা তথ্য দিচ্ছি।
My lord, regarding
After
this
5 years,
current case, my lord.
have been brought.
Where is that ground you have taken? Read petition এ কোথায় বলেছেন? That as per this ROPA, it's a non-relevant subject. I am entitled to get it after 5 years from the date of acquiring it.
Without prior permission by the DI, my lord?
No, that is not there. Kindly come with ROPA 98.
My lord.
পাচ্ছি না, আগের দিনও বলেছিলাম। এই যে রোপার যেটা আছে,
My lord, regarding the matter Utpal Kanti case,
এনেছে দেখি
special bench was Christian passed the order. Utpal Kanti Karan case, my lord.
উৎপল কান্তি করণ will
Not applicable without prior. Alice, my lord.
রিভাইজ পেজ প্রায়
The occasion was matter was heard, my lord.
No, not this one.
No, my lord.
All exam not relevant. I just scouting on data with such often. Note to be
What time now?
State governments.
3rd August 1984. The notification.
It is 372 EDN, that one 1980 ROPA. When you entered into service?
Well, in the year 1990.
24th
January 1990.
Physical education.
January 1990. 1990.
Yes,
then the 98 ROPA will apply. 86 ROPA will not apply. 90. We told you, Mr. Ali, come with those provisions. So we are not being able to decide.
Appointed হয়েছে কবে?
Appointment হয়েছে 91.
Appointed 91 and improved qualification in
2009.
2009.
91, my lord, the order also on the same book. My lord, kindly see page 888. My lord, I have flag mark, my lord, 888. Memo number, my lord, government order number 400, EDN, 10th September 1991. Hey, thank you, my lord, second copy.
That is relevant to.
No, not relevant, last week, my lord.
Relevant
all
subject.
existing secretary who are appointed with the higher qualification subject, not relevant to their teaching.
All teachers who were appointed with. You were not appointed with higher qualification. Higher qualification you got in 2009.
Yes, my lord.
No, my lord, or who improved their qualification subsequent, or to their appointment in subject not relevant to their teaching.
Who has improved
or
will improve their qualification, or who were appointed in the subject or group relevant to their teaching will get higher scale of pay to them, which will affect on. That is true. That is relevant subject.
You have ROPA 90.
All teachers shall be improved.
Same provision.
Non-relevant scale board of the
finance department achieve.
Non-relevant.
I have learned from my Damnet friend. There is a circular of the Department of the Finance. The non-relevant subject teaching or teacher can get that.
Show us. ওর অ্যাপয়েন্টমেন্ট হয়েছে, এটা হচ্ছে clarification to existing, that is prior to 1481 teachers. At 281. Did you file any opposition to the read petition?
No. There are
another lawyer.
There is another lawyer, my lord. In the
lawyer of
another lawyer state appeared.
You are not there.
No.
Mr. Swapon Dotto is there.
Swapon Dotto is there. I am not.
He is your leader in this.
Yes, all right, but I am not there. I am not. And regarding this matter, I am not there. I was not appointed as junior, my lord.
Then
if so, direct to file the opposition, I shall file.
No, you were subsequently engaged.
Yes, my lord, with Mr. Swapon Dotto. Swapon Dotto is appealing this case as DGP, my lord.
You are also for the state?
My lord. But trial court, I was not appeared.
Trial court we are not asking.
The matter was several occasion was heard by Lord without prior permission by the DI. A relevant subject cannot entitle.
If it is a non-relevant subject, he becomes entitled after 5 years of service.
My
That is what we are asking you.
All right.
But it was not the case of the petitioner before the court.
No. His case
The
was
petitioner case before the court was that I am taking a 6 plus a week,
My lord.
and hence I am entitled to get. And on a single judge held that even if you are taking 6 classes, you have to take that permission from that.
My lord. Case 66, my lord. Trial court was already explained
Should
and
have
discussion
taken
everything, my lord.
permission from the DI to allot 6 classes per week to you.
But the first application, writ petition was heard by the Honorable Justice Devashish Korgupta. Devashish Korgupta, Honorable Justice Devashish Korgupta was pleased to pass the order, consider to the case of the representation to consider. Then DI was pleased and passed the order, page 56, my lord. In compliance of the order of Honorable Justice Devashish Korgupta, kindly see my lord, page 56.
Your appointment was on?
24th January 1990.
Kindly see. 24th January 1990, my lord. Subject in work education.
24 January 1990.
হ্যাঁ, 90
I know DI.
এইটা হচ্ছে
pre 148 prior
Yes.
1st April
56.
No, thereafter, my lord, 400 memo, my lord, page 8.
That is ROPA 98.
No, page 90, my lord, 400 page.
Page
888, my lord, memo, government order number 400 EDN, 10th September 1991. B.
All teacher and librarian of the secondary school who will improve their qualification in the subject relevant to their teaching or appointment.
Subject not relevant, my lord, B.
Oh.
B. Or who improve their qualifications subsequent their appointment, subjects not relevant to their teaching will be allowed. B. 400, my lord, memo number 400.
All existing
পয়সা করে দিকে দাও না মানব দা
who are
আমাকে দাও
appointed
আচ্ছা তুমি 4 দিন ধরে একটা আমায় দাও
not relevant to their teaching or who improve their qualification subsequent the subject relevant.
এটার সাথে এটা মিলছে না।
না এটা নয়।
This is a Xerox copy from the book. 400 memo. The governor is pleased to make with effect from 1st day of April 1991 the following amendment.
Oh, এই জিনিসটা
This is a Xerox from the book.
তার মানে এইখানটা আছে 10 September 1981. We consider this fair decision in the light of this circular.
এটা কেস নয়। This is not case. কেস হচ্ছে 27 জানুয়ারি 95 ডিভিশন বেঞ্চের জাজমেন্ট। পারমিশন না থাকলে পেতে পারো। Now 6 classes, that permission was not given by DI, one thing. Second is you obtain the postgraduate qualification. That also requires a prior permission of the DI for doing that degree. But judgment, that is Ali Anwar Chaudhuri or something by Honorable Justice Pranab Chatterjee then was, that approval was not made necessary for this purpose. That is 2013 volume 2 CHN. We told you everything. You have neither.
2013, volume 2, CHN, page 568.
Yes, have you
The
read
prior
the-
permission is not required.
Not required. But your parent case is that I am entitled on the basis of 27 January 95 circular.
I have been allowed. I have been allowed to.
You have been allowed, but without permission of DI.
Yes.
That is exactly what is reflected in the order. How can we come out of that? Then show us something that irrespective of that fact, 98 rupees will get the benefit. Unless you show us, how can we? Oh, মুশকিল। Repeatedly, these are being adjourned.
It's a relevant subject, non, একটু কাজে লাগবে না।
Sir, you take instruction irrespective of 27 January 95. What is the problem if he is given from 5 years from his teaching, 5 years after he got the higher pay scale?
In the meantime, I shall take the instruction.
Come next week. No, next
Coming
Thursday.
after vacation, my lord.
Next Thursday.
Let it be after 22nd December, then you will know.
Yes. Next.
My lord.
In item 23, when in the last occasion, item number 23, I took the point of maintainability.
I'm for the private response number 7, 8, and 15. I am also raising the preliminary objection regarding maintainability.
I appear for the respondent 14 and 18.
Now, the last occasion, your lordship directed, my lord, the respondent number 7, 8, 12, and 15 to place their respective development agreement before your lordship, so that, my lord, we can identify the landowners. And, my lord, we have also filed an application, which is, my lord, CAN 1.
The lordship also left open the point of maintainability. I think, my lord, if the point of maintainability is the first hurdle my learned friend has to cross, then the question of production of the documents is required.
That is because they were implemented. He was saying some disturbance.
Absolutely, but at the same time, if I can
will consider, Mr. Sir. Then who is appearing for this? Are you appearing?
For private respondent 14 and 18.
You are appearing.
I'm the chairman.
For 14 and 18. Raghunath Chakraborty is
Yes,
there.
led by Mr. Raghunath Chakraborty, my lord. He's on legs, my lord.
7, 8,
Mr.
12.
Porko Kumar Nag.
7, 8, 12, and 15. Yes, where is Mr. Nag? You are sitting here.
I'm here, my lord, but I cannot appear anymore. I have been appointed.
At least you should tell us that. You are sitting behind Mr. Sahara.
Sahara is now there.
Oh,
Mr.
Mr.
Sahara
Sahara
is
is there.
replaced.
Oh, acha, acha.
I cannot.
Copy paste.
Not copy. He was Mr. Nag is now elevated, got the junior government, so he cannot appear.
So, Mr. Sahara, can you show us the
Point of maintainability.
We can. But I shall rely on a notification of our High Court, just for your lordship, regarding maintainability.
Just litigation maintainability?
Yes.
Yes, we will decide the point of maintainability.
If I can satisfy on that point, my lord, question of my lord, placing any document even does not arise.
No, Mr. Sir.
Because disclosure of
But the relevant respondents you said, whom you have not been able to serve?
My lord, they are, my lord, the landowners, the private respondent. Because we, my lord, collected their address from the website portal of Shuda.
And then Mr. Sahara is for the subsequent purchase.
For the developers.
Oh, he's the
Both
developer.
the developers and the landowners, their names were appearing in the, their website portal. Now, we implemented them, the address, what we gathered from the website portal. The portal, the address given in the development agreement, that has to be submitted at the time of submission of the building plan. Those were placed, and we are gathered the address from the website portal, but when we serve,
they are the owners of the land.
Owners of the land. And they are the person in whose favor the plan was sanctioned.
Only one thing I would like to point it out.
But Mr. Chardai, why don't you want, we have passed an order, no?
But we have brought.
So can we not, have you checked up whether the address differs? The landowner's address, which is.
No, not differs. So far, my lord, so far my clients are concerned, my lord, address are identical, same. So far my clients. I am for respond number 8, 7, 8 and 15. So for the service of others are concerned, I cannot. 7, 8 and 15.
Who are the landowners?
We don't know.
Last evaluator service.
Acha, then Mr. Bhattacharya, you are to meet the point of maintainability. Yes.
And only one way we have made an application, which is scan 1. Yesterday, we went to serve them, but they refused for addition of party.
This is the.
Let us decide the point
For addition of the party, because the duty inadvertently, the municipality has not been implemented, though the chairman has been implemented. So we make an application for addition of party.
Very good, we take note of that. Maintainability.
The municipality has not been made party.
Yes, we have made an application for addition of party.
That is the point of maintainability, and other point is.
This is one of our point, non-joiner of party. Chairman has been only made party, not by the municipality. Entire grievance against the municipality and the board of councillors. Neither the board of councillors nor the municipality has made party. So it is also barred by my lord. So far the non-joiner of party is concerned. Now he is coming with an application. Possibly that cannot be rectified.
No, why is the notification?
Oh, wait a
Institution of public interest litigation.
Yes. But before that, may I place the judgment, because it is a result of a judgment of the Honorable Supreme Court. 3 paragraph of a judgment. Supreme Court says you frame a rule to all the high courts. Accordingly, rule has been framed. That I shall show before that 3 paragraphs of the judgment.
Match of the address.
So far my client is concerned, there is no mismatch.
Then who, please tell us
Yes,
now,
madam.
who is the landowner you are wanting to implement? Carriage of proceedings is with you.
Yes.
14, respondent number 4, 13, 16 to 21.
The first paragraph of the order. Your Lordship, last order. First paragraph of the last order.
4, 13, 16 to 21 could not be completed. Yes, service complete.
No such person at the given address.
Yes.
It is an endorsement. No, on that date, it was stated that all the landowners or again in favor of whom the building plan was sanctioned have not been brought on record.
No.
And hence we can recollect, hence we ask the developer, you produce your development agreement.
Subject to
So
correction.
that we can find out
Subject to
who is the
correction,
owner.
this order of your lordship passed on the ground that those envelope was written with an endorsement that no such person. But it was submitted by on our end that we have given the address from their sanction, from their land sanction certificate.
So Mr. Shardai today says that the persons from whom I purchased, that address matches with the address given here. That is his contention.
Then we are helpless, because we are the address from their sanction certificate, the address given in their.
You are a local people, you are a political person.
For that, municipality should have been made party. Only assistance of the municipality is required.
That is the reason, my lord, we made that application, my lord, for addition of parties.
Possibly in that manner cannot be
You
done.
have given copies to them.
They have, yesterday we went to, they refused, my lord, but I have a
To
copy.
whom he is going to submit. I'm asking myself. I am appearing on.
ডাক করে কি হবে? একটা application করেছে, কপিটা নাও।
Chairman, he is
I
appearing
am
to
appearing
chair.
on behalf of the chairman.
How can
I have taken the point of
Chairman have a personal capacity.
Sorry, Milord.
Chairman is a personal capacity
Kindly,
of a representative of a body.
no, Milord,
Who is chairman?
body corporate, the company and the directors are the, in a different footings. But here, Milord, in this writ petition, they have chosen to Milord make the Milord the
So use an opposition to that and come back.
of
Take that point.
Technical.
of the
Technicality you are raising, you take an opposition, we will decide. Apart from that, we have to consider Mr. Shah's
Yes.
order to the effect that Supreme Court, there in the rule, there is a provision that public interest litigation,
Yes.
who will come?
I will also relying upon a judgment, Milord, whereby
Whereby the site is the
Alert.
OBC judgment.
2010 volume 2010 volume.
Mr. Harai, we considered this in our OBC judgment.
Yes, that I've seen, my lord, also.
ও আচ্ছা, আবার এটা থেকে ওইটা চলে
2010 volume 3 Supreme Court cases. Page 402, State of Uttaranchal versus Balwant Singh Choufal. I shall rely upon 3 paragraphs, my lord. Paragraph 154, 155, and 181. Paragraph 181 gives the suggestion as to which manner the rule shall be framed. And that has been done, and in the combined list of your lordships, that has notified each and every combined list. Page
154, 155 and 181.
my lord. And if you lordship kindly take up the combined list of your lordship, page 28, Roman 28.
কোথায় গো?
Each and every month it is being published. Shantish na kintu.
I have notification. 23rd August, no?
Yes.
ওটা তো দেখতে হবে।
Roman 28,
Roman 28.
XX5 III. This is 23rd August 2010.
Yes.
This is in terms of paragraph 181 of the judgment.
20 আছে। Yes. What you are showing, Mr.
Paragraph 56, definition of public interest litigation. Have a look at the second paragraph. Public interest litigation shall include a litigation, the subject matter of which a legal wrong or a legal injury caused to a person or to a determined class of persons by reason of violation of any constitutional or legal right or any burden imposed in contravention of any constitutional or legal provisions or without authority of law, or any such legal wrong or legal injury or illegal burden is there threatened, and such person or determinate class of persons is by reason of poverty, helplessness, kindly take note of poverty, helplessness, or disability, or socially or economically disadvantaged position, unable to approach the court for relief and for redressal of which any member of the public not having any personal interest, kindly take note of, in to approach the court for relief and or for redressal or which any member of the public or concerned interested in the subject matter of person and application for an appropriate direction, order or writ in this code of 26, notwithstanding anything contained above, in any appropriate case, though the petitioner might have a moved to court his private and interest and for appropriate personal grievances, the redressal of his grievances, the court in furtherance of the public interest involved thereon to treat the subject matter so and so. And if you also kindly take note of paragraph 181 of the judgment, the guideline. Before that, if you also kindly take, I'm handing over the judgment. First, your lordship, come to paragraph 154 and 155. 154 at page, my lord. 455 of the judgment page.
I can't. If court thinks that his patience is
দেখি দেখো মনে হয় purple.
এই CPC থেকে
The misuse of the public interest litigation at paragraph 154 and 155.
But for that, we have to hear him, Mr. Sir.
Absolutely. But I shall rely upon this judgment and two paragraph of the petition.
But why you are opposing impleadment of the chairman of the municipality?
Because on the because in huh?
without application.
Yes.
On the same note,
The court can.
there are
Without application of the party.
yes. But kindly
Thinks that
no,
is
that
the-
is all right. That is all. I am not opposing it.
So then when you are not opposing,
No, I am not opposing.
split the chairman.
No, military chair only
Municipality.
municipality will not do it.
And some other board of councillors.
I have no clue whether municipality will appoint me or someone else. They have to serve the municipality. Municipality, if it comes, and then I will appear.
Yes, we will implead.
But this is the judgment which my learned senior friend is appearing, relying upon. This is the latest judgment of the Supreme Court, whereby it has also relied upon the misuse of PIN. Kindly have a look, Millard. Para? বলে দিচ্ছি। Para 12 onwards.
এই একটা করে দেখা যাচ্ছে সেটা clear।
Judgment delay कुछ
2022
additional particular.
Where is saying that can one is in the list?
Can one in the list?
আমাদের কাছে এসছে can one টা?
Can one is chair?
2022 তে দিলাম কিন্তু মনে রাখিস
Can one টা আছে কি?
1986
When did you file it? Can one? Have you given copies to them?
One,
কি করছে?
we went to staff, they told that they'll collect the copies from today in course of hearing. We have one person received and another two.
Whom do you want to implead?
Mr. Raghunath
আচ্ছা
Chakraborty,
আচ্ছা, whom do you want to implead?
Sirampur Municipality.
দেখি application give a copy.
Paragraph, copy টা দে একটা, copy.
Board of councillors is also required to be added. Because chairman or municipality cannot take any steps. Under the law, my lord, board of councillors in a meeting can decide for the sanction, extension, renewal, everything.
Paragraph 3.
This is the power vested upon the board of councillors, not either not to the chairman, not to the municipality. And there are judgment also.
Sirampur municipality করতে যাচ্ছে. You are not wanting board of councillors.
Because they are the only sanctioning authority, they are the approval authority, they are the renewing authority.
Board of councillor will be represented by chairman also.
Yes, yes,
Huh?
yes.
So chairman is there.
Chairman is there.
And now another party board of.
Because my lord,
councillor
the law says,
by chairman.
it is, yes, represented by the chairman, but unless board of councillors made party.
officially has to be made.
There shall be defect of.
Yes.
So the application of addition of party being can one.
Indulgence. Item number 42. May I be permitted to file the paper books on health issue, my lord? I am in difficulty.
42
For monthly list of 42.
কত থেকে ডাকছি আমরা?
No, this is the monthly list will be called now.
হ্যাঁ হ্যাঁ
So 42, may I be permitted to?
কত থেকে ডাকবো আমরা month?
41.
41
And then again, 22 and 28.
22 to 28.
ডেকে দেবো এবার 22 but who is your other side?
Well, other side, I will inform them. They are Gaurav Das and Mr. Bari, Ekramul Bari.
So you file now. You file when it can taken up for hearing, you tell us, we will take it on.
My lord, long waiting is prohibited for me, my lord. For that reason, so I can do it online.
You file the paper book.
Oh, yes, yes. Then it is.
Not here. You give copies to them and when are we?
That is hard. It is
Very good. When we call the matter, we will hear it from there.
We will be taken on record. We will be taken on record.
Well, paper book is not on record, but I
We understand.
It will be taken on record.
Take it on record.
At the time, it will,
Of the
matter will.
ওই তো গৌরব দাস পেয়েছে।
Wait to Gaurav.
You have got it.
But let it be taken.
Mr. Das, you that non-relevant subject.
And I also